or all the cell phones and so forth need to be turned off, not just silenced, because the alarm still get through. We are also still using masks as an abundance of caution. Now, once we have a jury selected, we have fewer people in the courtroom, then we'll leave that and wear and see inside your things there. Unless you have a medical issue, in which case they don't know. During the time you're being questioned, answering questions during the selection process, you can take the mask down and counsel. The Supreme Court's going to be meeting tomorrow to discuss lifting their restrictions of their Columbus, and so we're kind of waiting for that. I anticipate we're going to be moving this to optional at the end of the week. But for today, since we actually have people, we're still going to exercise caution. All right. Now, this is first of all, I'll ask the persons that are involved in the case to introduce themselves. We'll start with this is a criminal case, State of Ohio versus Brandon Jonathan Engel. So on behalf of the state.
Good morning, ladies and gentlemen. My name is Anna Collins. I'm Ohio County Prosecuting Attorney. With me this morning at council table is Deputy Steve Alexander from Ohio County Sheriff's Office.
All right, Mr. Deardorff.
Good morning, my name is Alex Deardorff. I have the pleasure of representing Brandon Engel, the city of Kansas.
All right, thank you. All right, now, as I indicated, this is a criminal case. The defendant has been charged in a 2-count indictment, which I'm going to read to you simply for the purpose of informing you as to what the case is about. And the allegation in count 1 is that on or about August 30, 2018, the defendant did by force, threat, or deception, knowingly under circumstances creating a substantial risk of serious physical harm to Dustin Hunter, restraining the liberty of Dustin Hunter, and the defendant did not release him to save the place unharmed. That is the charge of kidnapping. Count 2 alleges that on about the same day, the defendant did committing attempt offense as defined under ORC 291302 or immediately after the attempt offense did inflict, attempt to inflict, threat to inflict physical harm on Dustin Hunter. That's a charge of robbery. Now, an indictment is not evidence of a crime. The fact that a defendant has been indicted is simply an indication of how the case came to come to court. Because the grand jury does not determine guilt or innocence, it's simply whether or not there's sufficient evidence to bring the case before the court. And so the fact that it was indicted means nothing more. Because every person who is charged with a crime, whether it's through an indictment or filing a complaint, is presumed to be innocent until proven guilty by the state of Ohio on every essential element of an offense. And so that is the bedrock of our justice system, and one by which you will be required to honor, as I will explain to you here in a few minutes. Now, as far as preliminary is concerned, all of us are aware, very acutely, that none of you volunteered to be here today. You were all drafted and chosen through a jury poll, actually occurred last October, and then we divided the year up into terms, 3-month terms, and so we're selected in that pool driven drawn in October at the end of the year. Now, we understand that it's going to disrupt your schedule, and it's going to be different than the normal routine, maybe missing work or other matters that you would normally be doing. But the fact is that service on jurors by citizens was an important foundation of our founding, and is enshrined in the Bill of Rights. And it is one of the most important principles that we have in the administration of justice, because the majority of countries in this world don't have the right to have a trial by their peers, by jury. And so when you are called to serve, and if you do end up being selected, I hope that you would look at this as not something that is a burden, but it is a duty of citizenship. So you can help contribute to the perpetuation of our democracy as intended by our founders. And so as you are questioned today, as you will be in a few minutes, I hope that you will keep that in mind. Now, if you are selected for this jury and serve on this jury, which we anticipate will be a day-long trial, then you'll be excused from service through the rest of the term. The term actually ends at the end of the month, so there's another three weeks or so. And so if you're selected to serve, you won't be called. The others that are not selected would be subject to being called through the end of the month. Now, we will do everything we can to keep this case moving quickly, and again, as I said, I expect we will finish the case today. We will take breaks about every hour, 15 to hour and 30 minutes. We'll be exactly on that. It just depends on how the case is flowing, but we'll try to make sure that everybody stays comfortable. And then we will anticipate having the case submitted to the jury this afternoon. Now, there is no particular timetable for the determination of how long the case will take for a jury to deliver. So I let the jury make that decision. So as we go on in that process, once we get to that process, the jury will be the one that makes that determination. And so we don't let people go till midnight, but sometimes they go in the evening. And then if the jury wants to take a break and come back in the morning, we can do that. I don't anticipate that. That happens once in a while, but not that often. All right, now, I'm going to give you some instructions before we start jury selection. Under the law, the judge is the one who enforces the rules that are set by the legislature and the courts, the Supreme Court, and of course the courts of appeal that are over trial courts. And under the law, it is your obligation as prospective jurors, and then if you're seated as jurors, to follow the instructions of law that are given by the court. Now, I don't know how many of you served on juries before. That will probably be inquired by the counsel, but when somebody comes in a panel, I've seen it over my almost 46 years of practicing law now, that often the first thought is, well, I wonder what that person did, why are they here, and that we need to have a trial. Well, the fact of the matter is that every person is presumed innocent until they're proven guilty. And so, as the defendant sits here today, he is presumed innocent and will remain under that presumption until and unless, at the conclusion of all the evidence and all the instructions of the court, the jury finds that the state has proved his guilt on either or both charges by proof beyond reasonable doubt. And so, if you were asked to vote as a prospective juror today, many of you would probably say, well, how could I vote? I don't know anything about the case. That seems normal, doesn't it? That seems logical. That's the first thought that any person would have. But the law says that he's presumed innocent. And so, since there's a presumption that he's innocent, if you have no evidence to make a decision on, then you have to say he's not guilty. And so, if that were the vote right now, and I said to the 12 of you, make a decision on whether this person is guilty or not guilty, your verdict would have to be not guilty under the law, because there has not been proof beyond reasonable doubt. So that's what the presumption is of innocence. Try to get explain that in terms that are clearer than perhaps what the legal language explains. Now, if we should take any recesses during the, normally we are able to finish a selection of a jury without a recess, but if we do have to take any recesses, do not discuss the matter at any time during those recesses with anyone, with each other. Don't attempt to talk with any other folks you see here inside the well, the bar, and do not allow anyone to talk about it. Don't talk to any strangers or people like spectators or anything like that. Now, each of the parties are entitled to have a jury that is composed of persons who will approach the case with open minds and keep it open until the conclusion of the case and the instructions of the law and deliberation. And so each juror that is selected must be as free as possible from any possible bias, prejudice, or sympathy, and are not influenced by any preconceived that you may have as to the facts or the law. Now, all of you are doubtless qualified to serve as jurors in the case, but it may be something about your experience or your knowledge of your situation that would make it possible for you to serve in this particular case. And so that is why we have questions and ask jurors, prospective jurors, a number of things. Now, everyone may have, and undoubtedly does have, predetermined ideas about some matters, but our system is based upon the principle that jurors who decide a case will decide it with an open mind. And so therefore, when you are questioned during the voir dire by the court and attorneys, it's important that you be as frank and open as possible when answering questions, because there's nothing wrong with acknowledging that there may be something about your particular experience or situation or knowledge that would make you unsuitable to be a fair and impartial juror in this particular case. This kind of honesty and openness is what allows our system to work effectively and constitutionally. So, since we're going to be asking you questions before we proceed with that, the clerk is going to administer what's called a voir dire oath. Voir dire is a term we use to reflect, to talk about jury selection, where we are asking jurors potential questions. It's a French idiom that actually means to speak the truth, and that's why you are required to take an oath or affirmation as you prefer. So, Mr. Hodson will administer that this time.
Please rise. Raise your right hand. Do you solemnly swear or affirm that you will truly answer all such questions as may be lawfully inquired into, touching your qualifications as a juror, as you shall answer unto God or under the penalties of perjury? If so, please answer, I do.
Thank you, Mr. Hodson. All right, now, the attorneys ask most of the questions in jury selection voir dire, but there are certain questions that the judge is required to ask all jurors. And so I will ask them at this time, and if it applies to you, hold your hand up so I can inquire. And make sure to keep my range of vision over there. All right. Now, in order to be a juror in this case, you must be a legal resident of Highland County today. As I mentioned, we drew your name actually last October in the general pool, and then for this term in December. And so, if you have moved since then and no longer live in the county, you're no longer a resident and not qualified to be a juror. And so, are there any of you who are no longer living in Highland County at this time? This is actually an obsolete question, but I'm still required to answer it. But the indictment in this case was returned in July of 2020. Are there any of you who served on the grand jury that returned the indictment in this case? Now, are any of the prospective jurors or your spouses a party in a case in which either of the attorneys is involved, whether they're representing you, your spouse, or someone else in the matter? Has anyone been subpoenaed to be a witness in this case? I've actually had that happen twice. Are there any of you who are on the prospective panel that have an action pending between you and the state of Ohio? That could be a criminal or traffic case, could be some kind of licensing case, eminent domain, or any kind of a dispute with governmental agencies, or anyone that has anything of that nature as of today. Okay, now I'll ask this question in the legal language and then I'll explain it. The question is, are any of you related by consanguinity or affinity within the 5th degree to the person alleged to be injured, Dustin Hunter, or the defendant? Now, what that means is consanguinity means by blood and affinity means by marriage. So the question is, to your knowledge, are any of you related by blood or marriage to either Dustin Hunter or the defendant? Okay. All right, now, are there any of you who are an employer? Let me rephrase it. Are any of you, or your spouse, or children, or parents, an employee or employer of the prosecutor's office, or the defendant, or defense attorney? Final question. Are there any of you on the panel for whom English is not your native language? In other words, were you born in a country in which English is not the official or dominant language? All right. Then the court determines that all of the prospective jurors are qualified to this point and will be questioned then by the attorneys. Now, you notice when you see that you in a particular order, we have a chart. Again, we've made modifications because of the COVID situation the last couple of years. This is the first trial we've actually had for about 7 or 8 months. But the instructions of the jury, to the attorneys are just to question the first 24 of you. And so there's 12 of you in this group over here and 12 of you that are sitting on these benches. So they're going to ask you 24 of the questions. The reason I have them do it that way is because 90% of the time we're able to get a jury and an alternate within the first 24, and so it just slows things down and ends up delaying the process if we have a question everyone. Now that doesn't mean that the other 9 of you, I believe, we have in the room, we actually have a few more across the street who are watching this on YouTube. That doesn't mean that you're not to pay attention. We do want you to pay attention, and because in the event we do have to have a question, it would be helpful for you to be able to follow along and answer more quickly and bring things up when I have the bearing on the matter. All right. So the state of Ohio has the burden of proof in a case, and so because of that, they have the right to ask questions first, and then after the prosecutor has concluded her questions, then Ms. Booth will ask questions on behalf of the defendant. At this time, I'll turn this over to Ms.
Good morning, ladies and gentlemen, again. I first want to tell you that the questions that I will ask, and the questions I'm sure Ms. Theodore will ask, are not meant to embarrass you or put you on the spot or anything like that. Some of them might be a little probing, but we just want to ensure that we have a fair and impartial jury. We're just going to listen to the testimony, review the evidence, and make a decision based on what we learned before today. So that being said, this is the only time during the trial where we get to talk with you and you get to talk back and act like you're really excited to be here. The first thing you thought when you woke up this morning was, great, we get to go to prospective jurors in the case. Yeah? Okay, so not so much. So first, does anyone know me either personally or professionally? I grew up in Highland County. I've been in the prosecutor's office for 16 years, basically all of my legal career, and been the prosecutor for 11 years. Does anyone know me either personally or professionally? Just raise your hand. Ms. Cook? We're going to have to pass the microphone down to you. Okay. Hi. And how do you know?
You were best friends with my daughter.
So, Emily is your daughter, and literally grew up down the road from you. So, I've known Emily since kindergarten. She's spent the night at your house. She's spent the night at my house. As we've gotten older, I went away to school, and we've kind of grown apart. When we see each other, we say hi, but not like we were when we were kids. Do we talk about, when I see you, do we talk about work or anything like that?
No.
Does Emily ever tell you, hey, this is the case that Emily just got going on?
No.
Have we spoken about this case at all?
No.
So is there, do you think that you can listen to the testimony, review the evidence, and make a decision based on what you learned in court today?
Yes.
Putting aside the fact that Emily and I were friends with her. Thank you. Anyone else? What about Molly Bolwick, Molly Wyrick? She also grew up here in Highland County, and she's an assistant prosecutor. Adam King, does Does anyone know him, either personally or professionally? He's also an assistant prosecutor. Jim Rader, I'm sorry, hold on a second. They've got to pass the microphone to you.
I was Adam's fifth grade teacher.
Okay, the fact that you are Adam's fifth grade teacher, if you see him come into the courtroom or anything today, is that going to?
I doubt if I know him, because he was 10 at the time.
He doesn't look much different.
That's about all.
Is that going to impact your ability to be a juror today?
So,
Okay, you can still listen to the testimony, review the evidence, and make a decision based on what you learned in court?
yes.
Okay, thank you. And then, Jim Rader, who's, the other assistant prosecutor. Yeah. What about, Randy Sanders or Chris Bowen? They are both investigators in my office, and you may see them at some point bring something in or something like that. Does anybody know either Randy Sanders or Chris Bowen, either personally or professionally? Deputy Steve Alexander, who is sitting at council table. Does anyone know Deputy Alexander? Sergeant J.D. Adams. Does anybody know J.D. Adams? What about Dustin Hunter? Judges asked you this, but I just want to make sure. Cheyenne Volmer. Does anybody know Cheyenne Volmer? What about Brandon McComas? What about the defense attorney, Ms. Deardorff? She is from a firm in Cincinnati. Does anyone know her, either personally or professionally? Or the defendant, Brandon Eagles? Does anyone know him, either personally or professionally? Have any of you read or heard anything about this case, maybe in the paper or social media, anything like that? I haven't seen anything about it, so. Now the judge is going to tell you, you've already heard it a little bit this morning, that the state must prove its case beyond a reasonable doubt, and the judge is going to give you an instruction specifically on what reasonable doubt means. But basically, reasonable doubt equates to the big decisions that we make in our lives. And it's doubt based on reason and common sense. It's not your duty to look for reasonable doubt if it's in the case or present itself. But it is a high burden of proof. Can everyone agree to hold me to the standard of proof of beyond a reasonable doubt? Yes. Come on, guys. But it doesn't mean beyond all possible doubt, like there's no question. It doesn't mean that. Can everybody agree to follow those instructions? Okay. The next question I asked is based on a case that we all watched here in the courthouse because we thought it was extremely interesting. I found out that we are not in the majority in finding cases interesting. In Cincinnati, gosh, I don't know how many years ago, probably around 14, there was a case called the Whitmer case where a man was charged with killing his wife. And in the case, the evidence showed that when EMTs arrived, the wife was laying on the bathroom floor. And it was alleged that she had drowned in the bathtub or fallen and hit her head and died somehow in the bathtub. And that he had pulled her out and that he had tried to resuscitate her, but no avail, and that was that. Well, the jury gets the case, and they start deliberating, and they go home. A big issue in the case was the fact that her body was dry when paramedics arrived, because it only took them a few minutes to get there. And if he had really pulled her out, called 911 right away, and tried to save her, then the body should have still been alive. So the jurors went home the first day of deliberation, and they all took a shower, and when they got out of the shower, they stood in front of the mirror and timed themselves to see how long it took for their bodies to dry. And when they realized how long it took, they found them guilty. Well, that had not been evidenced in the case. They kind of did that on their own. So when it was found out that they did that, they had performed this little experiment on their own, the verdict got the case got remanded, and they had to retry the case. So they tried it a second time. And then there was some sort of jury tampering the second time. So they ended up trying the case a third time. And after the third time was a charm, I guess, and the case is finished now. So the reason that I ask this is because I'm asking you that, you know, at the end of the day, or whenever you get this case to start deliberating, that you not do any of your own experiments. Don't research anything online, don't, nothing like that. Can you all agree not to do anything like that? How many of you have heard of a victim case? One person. I feel like a nerd when I talk about that, because we watched it like it was the only Simpson trial 2.0, but no, nobody else. Does anybody here heard of circumstantial evidence? Okay. So circumstantial evidence, and the judge is going to give you a really specific instruction on this, but basically it's drawing an inference from evidence and testimony. So I have an example I always use because it's easy and I understand it. If you go to sleep on Christmas Eve and there is no snow on the ground, and you wake up Christmas morning and there's 3 inches of snow on the ground, even though you were asleep and you didn't see it snow, you can draw the inference that it snowed during the night, right? You didn't directly see it, so you don't have direct evidence of it because you didn't see it. But the circumstantial evidence is there. There's snow on the ground, so you can draw the inference that it's snowed. Understand that? We all agree that we can draw inferences from different things using our common sense and come to conclusions based on that. Who here watches CSI, Law and Order? They're bringing back the old Law and Order. They're bringing it back now and running this. Who watches? Me too. I love this stuff, and it's absolute nonsense. There is the stuff they do. I don't understand. First of all, we can't get fingerprints out of running water. There are no satellites in the sky watching. If there are, we don't have access to it. We don't have any sort of crime lab here. We aren't, there's no pig on the courthouse roof that we're growing bugs on or anything like that. That's craziness from CSI. But we've kind of gotten into, well, if they can do it on TV, then they must be able to do it in real life. And people have asked, well, why didn't you have fingerprints, even though he was wearing gloves? Well, because it's just not the way it works. So can you all agree not to hold me to the CSI burden of proof? Yeah. Now, the defendant may or may not testify, and that is totally his decision. No one can make him testify, no one can keep him from testifying if he wants to. It's his right completely. Is there anyone here that will hold it against him if he chooses not to testify? Has anyone here been a victim of a crime? Mr. Sealy?
Mm-hmm.
Can you tell us about that crime?
I'm sorry?
Can you tell us what crime that was?
Just some theft.
Unfortunately, around here, we have a lot of that.
Yes.
Do you know, did you report that? Did you report the theft?
Yes.
Was it investigated?
Yes.
Who investigated? What agency?
Well, some here and some in Warren.
Okay. Were they able to solve it?
In one case, yes.
And was someone prosecuted?
No, they did not prosecute me.
Was that here or in Warren?
Warren, yeah.
Okay. Well, I can't pretend I understand, but do you have any animosity toward law enforcement or the state for not prosecuting them?
No, not really.
Okay. Anyone else? Okay, so prior to going to law school, my knowledge of the law was based largely on what I saw on television. We don't have a reason to pick up a law book and start reading cases, right? It's not what most people do on their Saturday evenings. So, needless to say, I was a bit surprised when I started law school and discovered my wealth of legal knowledge was really just nonsense. So prior to law school, I believed a crime like kidnapping meant that a child was abducted, maybe walking through the park and somebody in a ski mask jumps out and grabs this child and sticks them in the panel van and drives off, right? That's what we think of when we think of kidnapping, right? But that's not the law. It's not even kind of law. There is no requirement that kidnapping even involves a kid, despite the name kidnapping. So I only bring this up because I'm going to ask that you put aside your preconceived notions of what the law is and just agree to follow the instructions that the court gives you. If you are chosen for jury service after the trial, you'll be read first and given a thick set of, maybe this thick, of instructions that detail each and every crime and what the definition of each and every element of each and every crime. So can you all agree just to put aside what we think we might know about the law and follow the instructions that the judge gives? Now, the defendant has been charged with kidnapping and robbery for causing a substantial risk of serious physical harm to someone. Has anyone here been involved in a situation where they suffered an assault like that? Or any sort of assault? No? Has anyone here ever heard of complicity? Or we probably have all heard of aiding and abetting. So the best example I can give you of aiding and abetting is, how many of you have seen the movie Point Break with Keanu Reeves? Not the new one, but the old one, the good one with Patrick Swayze and Keanu Reeves in it. You know, with the bank robbers that jump out of airplanes. Tremendously good movie. Okay. So the best example I can give you of complicity is the bank robbery. Bank robber 1 and 2 are in a vehicle and they pull up in front of Merchants Bank over here. Bank robber 1 is the getaway driver. Bank robber 2 is going in. When he goes in, things go south and he shoots a teller. He comes back out, gets in the car, and bank robber 1 drives the 2 of them away. Bank robber 1 has committed murder because bank robber 2 shot the teller in the bank. That is complicity. You are equally responsible for the other's actions. You understand that? That's why Keanu Reeves was so worried when Patrick Swayze started shooting people in the different work. You guys haven't seen it, you see it. So if the judge tells you that a person can be found equally responsible for the actions of their co-defendant or the person they're complicit with, you all agree to follow that instruction? I have just a few questions for you. Ms. Arnold? Hi. You've never been a juror before? And not been the victim of a crime? Is there anything the state or defense should be concerned with if you were chosen as a juror today? Okay. Thank you. Mr. Sullivan?
Yeah.
You've not been a juror before?
No.
You indicated that you have family members that have been convicted of crimes.
You think that?
Did you indicate that on your jury questionnaire, maybe?
Not that I know of.
Okay. You also indicated that either you or someone in your family has been the victim of a crime?
Before, probably when I was a kid.
Okay. All right, is there anything the state or defense should be concerned about if you were chosen as a juror today?
No.
Okay, thank you.
Well,
Mr. Honeycutt, you've not been a juror before? Never been a victim of a crime? Anything the state or defense should be concerned about if you were chosen today? Mr. Hallett, you indicated that you've been a juror before?
Yes.
Was that here in Miami County? Do you recall what kind of case that was?
There's something about,
Was it here in this courtroom? No? Municipal court case then, probably. Okay. And, were you able to reach a verdict in that case? Do you recall that verdict? I can hear you. Okay, thank you. And you indicate that you've been you were a teacher, but you no longer a teacher?
No.
Okay. All right, thank you. Mr. Dalton, you've not been a juror before? And never been a victim of a crime? Is there anything the state or defense should be concerned about if you were taken today? Thank you. Ms. Brooks? You've never been a juror before and not been a victim of a crime? You have little ones at home? That's taken care of for the day? Okay. So there's nothing the state or defense should be concerned about if you were chosen today? Okay, thank you. Ms. McNeil?
Yes.
You've not been a juror before
No.
and not been the victim of a crime?
No.
Okay. Is there anything the state or defense should be concerned about if you were chosen as a juror today?
No.
Okay, thank you. Mr. Harless?
Yes.
Have you indicated that you've been a juror before?
No.
No?
No.
And you've not, did you indicate that you or a family member has been a victim of a crime?
No.
Okay. Is there anything the state or defense should be concerned about if you were chosen as a juror today?
No.
Okay, thank you. Ms. Cook, we've already been through how you and I know each other. Have you been a juror before?
Yes.
Was that in a criminal case?
It was a bad circuit case.
Really?
You know the people too, so.
Okay, I'll ask. Is there anything the state or defense should be concerned about if you were chosen as a juror today? Thank you. Mr. Fisher?
Yes.
Not been a juror before?
No.
No, and not been the victim of a crime?
No.
Is there anything the state or defense should be concerned about if you were chosen as a juror today?
No.
You indicated that maybe a family member has been convicted of a crime?
Yeah.
Was that here in Highland County?
No.
No. Do you hold a grudge against the state of Ohio because of that? Or law enforcement? No?
No.
Okay. Mr. Kelly? You've never been a juror before?
No.
Okay, you indicated, have you or a family member been the victim of a crime?
No.
You indicated that, you or a family member has been convicted of a crime?
No.
You didn't indicate that?
I don't believe so, no.
A theft offense?
I was not a victim. I was,
Convicted.
oh, yes, sorry.
Okay. Do you hold a grudge against the state of Ohio because of that?
Absolutely not.
Okay. All right, is there anything the state or defense should be concerned about if you were chosen as a juror today?
No, ma'am.
Okay, thank you. Mr. Smith? Have you been a juror before?
No.
No? And not been the victim of a crime?
No.
Is there anything the state or defense should be concerned about if you were chosen as a juror today?
No.
Thank you. Ms. Pence?
Yes.
Never been a juror?
Yes. I think when I was about 20, 21,
Okay, here in Highland County?
Greenfield.
Oh, okay, that was probably the last time I had a jury trial. Is there anything about that experience that would impact your ability?
I can't remember.
Can you remember it? Okay. I'm going to get something over. Nothing the state or defense should be concerned about if you were chosen today?
You asked her if she had children and they were taken care of. I babysit my grandchildren. Luckily, today my daughter's off work. I'm the only babysitter. If it goes over, I don't know.
I mean, I can't,
You just said be honest, so I don't know
right,
if that's an issue.
I can't say, 100% that we'll be finished today, but I anticipate that we will be.
Okay.
I mean, I don't.
And that's
it.
fine.
Okay, perfect, thank you. Mr. Sealy?
Yes,
Have you been a juror before?
I was false that did not sit on the trial.
Huh. Gosh.
Warren County.
Warren County.
Yes.
Okay. And you don't hold a grudge against the state because of whatever they did with your case up there?
No,
Is there anything the state or defense should be concerned about if you were chosen as a juror today?
not really.
Okay, thank you. Ms. Hart?
Yes.
Never been a juror?
No.
Not been a victim of a crime?
No.
So I think you're probably the youngest person in our jury pool.
Today is my birthday.
Oh, happy birthday.
Thank you.
So, listen, you're 21.
Yeah.
Big birthday.
Yep.
So, if you are chosen as a juror today, and you are back, oh, you don't go back to the jury anymore, but you are here deliberating, and the other 11 people who are going to be older than you are saying, nope, it's this way, this way, this way, this way, this way, and you feel differently, are you going to be able to stand up to all those people and say, I'm holding my own, I'm not giving in just because you said so?
Yes, I think I could. All the people I work with are older than me, so I do this every day, yeah.
Okay. All right, well, happy birthday.
Thank you.
Ms. Frazier?
Yes.
You've not been a juror before?
No.
And I assume work's taken care of because you're here. So
Yes.
as a bus driver,
Yes.
you'd be there.
Well, I'm in between rounds right now, so.
Is there anything the state of defense should be concerned about if you were chosen today?
No.
Mr. Carter? Not been a juror before?
No,
And have you or a family member been a victim of a crime?
no.
Is there anything the state or defense should be concerned about if you were chosen today?
Contrary, I am youngest. I'm 19, just turned it about a couple months ago. As for concerns, I do have an uncle, an older uncle, that lives with me and my dad. If anything were to happen, I am the only other one that's willing to do anything or come home and take care of him. But as far as I know, that should not be a problem as of right now.
So then the same question to you as to her. You were sitting in the jury room as well, which is now the courtroom. And you are being told by the other 11 who are going to be older than you, you've got to change your mind and do this. Are you going to go to stand up and hold your own?
If I was any younger, no. But as far as I'm aware, my social anxiety is under control.
Okay. All right, thank you. Mr. Waters?
Yes.
You've never been a juror before?
No.
Not a victim of a crime?
No.
Is there anything the state or defense should be concerned about if you were chosen today?
No.
Thank you. Ms. Bennett?
Yes.
Not been a victim of a crime?
Nope.
And never been a juror before?
Nope.
Is there anything the state or defense should be concerned about if you were chosen today?
No.
Thank you. Do you guys have a baby chickens where you work there? Mr. Roth?
Yes,
You've been a juror before?
yes,
Do you recall where that was?
Portsmouth, Ohio,
Okay. Do you remember what kind of case it was?
drug,
Drug case. Do you recall if you were able to reach a verdict in that case?
yes,
Do you remember what the verdict was?
guilty,
Okay. And is there anything about that experience that would impact your ability to be a juror in this case?
that was history,
Okay. Is there anything the state or defense should be concerned about if you were chosen as a juror today?
Not that I'm aware of.
Okay, thank you. Ms. Borfit?
Good morning.
Did I say your name correctly?
Yes, ma'am.
Thank you. Not ever been a juror before?
No, ma'am.
And never been a victim of crime?
No.
Anything the state or defense should be concerned about if you were chosen as a juror today?
No.
Thank you. Mr. Ryan?
Yes.
Not been a juror before?
No, ma'am.
And never been a victim of crime?
No, ma'am.
COPD for a living, but I assume that that's on hold for today. Anything the state or defense should be concerned about if you were chosen today?
No, ma'am.
Thank you. Mr. Pritchett?
Hello.
Hello. Not been a juror before?
No, ma'am.
No. And never been a victim of a crime?
No, ma'am.
Is there anything the state or defense should be concerned about if you were chosen today?
No, ma'am.
Okay, thank you. Ms. Sanders?
Yes.
You've never been a juror before?
No.
You indicated that maybe a family member has been convicted of a crime. Was that here in Highland County?
Yes.
Do you hold a grudge against the state of
No,
Ohio?
not at all.
Or law enforcement?
Not at all.
Okay. Is there anything the state or defense should be concerned about if you were chosen today?
No.
Thank you so much.
You're welcome.
That concludes my questions. Thank you all.
Thanks. You're open to answer the defendant.
Thank you very much.
Good morning, everybody. I'll do my best to not repeat because the prosecutor covered a lot of what I was going to ask. But I did want to talk about a few things. So I'm going to start, just put people on the spot. I apologize. Ms. Armin, did I say that correctly? Okay. So I saw in the questionnaire that when you were asked, are you related to or close friend in law enforcement, you have several answers. Okay. And the reason I ask that is you're going to hear from, I believe, at least one police officer in this case, okay? Do you think you're going to have a hard time if a police officer gets up and says, I believe that this happened this way? And then the defense is obviously disputing that. Do you think your relationship with police officers may make that difficult for you to disagree with them? Let's say that to come back with a verdict that might not be what they were asking for? Is that going to hard for you? Okay. And I'm going to open that question to everybody because I know a few other people put that down. I think, was it a brother of yours as law enforcement?
Yes.
Okay, the names look very similar. Same question, I think if my sister is a school teacher, if a teacher got up and then the defense is up saying, oh no, that they're wrong. We're asking for a not guilty, obviously that's not what the police is going to be saying. Do you think that's going to be difficult for you in the back to come back and say, we disagree with them?
Absolutely. My brother and I are siblings, brothers are, but we disagree all the time.
Okay, fair enough. Anybody else think that might be difficult for them? Just even on a subconscious level? Okay, thank you. And Mr. Sullivan, did I say that right, sir?
Yeah.
So this case you're going to hear from, it's different than like a DUI or something where there's a real victim. And you're going to hear from someone that is a real victim in this case. Do you think, when you think about the court process, have you ever heard people say justice for blank and say a victim's name?
No.
You've never heard that? Anybody hear that before? Justice for whoever, if it was, if they were assaulted or something more violent, like shot. Has anybody heard that before? By show of hands. Okay. And part of what the instructions will say to you is that sympathy or emotions of a case are not to actually enter your deliberations at all. Do you guys think you'll be able to do that effectively, like set that aside when you're in the back and not say, well, I feel really bad for him that he got up there and said all this, that actually what you're deciding is whether or not somebody committed a crime. And they're kind of two different things. Does that make sense? You want to pick on juror number McNeil? Did I say your name right now? Is that your name now? McNeil? McNeil, I'm sorry. Does that make sense to you? That you're not really here to get justice for a victim, but you're deciding whether or not the state of Ohio proved that a crime was committed. You see this slight difference?
Yeah.
Okay. Anybody have a problem with that? Okay. Mr. Honeycutt? Okay. I want to talk to you a little bit about one thing that the prosecutor touched on, which was complicity. You know, we're using the example of the getaway driver and things like that.
Yes.
Okay. Do you think it's important, or tell me what you think, what evidence would you look for in a case that involved the driver?
They were willing participant who knew, what the, I guess, objective of what they were trying to do was.
Okay.
Acted, did.
Have you ever heard of the word criminal intent?
Yes.
Okay, what does that mean to you?
They were intending to do something they knew was a criminal act beforehand.
Okay. And the example the prosecutor gave was, you know, they pull up right in front, the one person goes in, shoots the teller, unfortunately gets back in. So, to show they're involved, you can see like a video of it, maybe outside, they pull right up. And the fact that the person gets back in and they peel away. Like that's little facts like that. And I bring that up because it's kind of hard to guess what's in the mind of the person. Is that fair to say? Right. So you look towards other facts and circumstances of the case. And the judge will give you that instruction that you can't really read people's minds, but that's what you guys are going to be looking at, facts and circumstances of were they willing, were they not, things like that. And I'll use this example. It's different, would you agree that the getaway driver situation is different than you coming up to me and saying, hey, can I have a mask, like a COVID mask, and I give it to you, and then you run outside and rob juror number 2. Do you think that, is that different than the hypothetical she gave? Do you see the difference there?
Yeah, depending on what the action is.
Sure. Does everybody else kind of see those distinctions and if that's important in a case like that? Okay. Thank you, sir. Ms. Mahalik, did I say that right? Okay. I wanted to talk just briefly about, do you remember the prosecutor talking about reasonable doubt and that she has the burden to prove to you, beyond a reasonable doubt that this crime occurred and that my client did that? Okay. And do you remember she said, it's not all doubt? Remember her saying that? Would you agree that, what if you're not sure?
I mean, how would you have to vote?
Well, what would you be thinking, what does that tell you if you're not sure at the end of the case?
And it wasn't proven, not doubt.
Okay. And do you kind of see the difference between unsure is covered? Do you understand that unsure is covered under not guilty?
Yes.
Okay. And why I bring that up is, in our day-to-day life, anybody here, like in a supervisor role at their jobs? Oh, that'd be comfort to them. Have you ever had to listen to 2 people tell something and kind of make a decision of who you believe more?
Yes.
Okay. How do you do that?
Well, we dig into both sides and then see if there's other people who may have witnessed it as well. And then there's not just me, but our HR and stuff we sit down.
Right.
And
Kind of look at everything.
Yep.
So would you agree in our day-to-day life, though, it's natural for you to pick one or the other?
I can't say it's impossible, but I try very hard.
Okay.
Stay neutral.
And I bring that up because in our day-to-day life, you hear something, one person, you hear something from another person, and it's our nature to kind of side with one or the other. You know what I mean? And in this room, would you agree that we don't have to prove anything to you under the law? Okay. Do you think that's fair?
Yeah.
Okay. And I say that because I think when you go back there, I want to make sure that the decision you're making is not, do I believe Ms. Beardorf more or Ms. Collins more? And that's how you vote, not go through votes based on that, but really just, did they prove it to you? You see the difference there?
Yes.
Okay. Thank you, I appreciate your candor. Ms. Brooks, is that your name? Actually, if it's easier, I can just go start back there. With Mr. in the back, Mr. Fisher. Is that your name, sir?
Yes.
Okay. Do you think that it's fair that in our system, what it takes for somebody to be arrested for something is different than what it takes for someone to be found guilty of something?
Yes,
You think that's fair or no?
I guess.
Why?
If I don't know.
So
It's hard
I
to
totally
me.
got
I
to
can't
figure out
really judge what, if I don't see something, I can't judge it. You know what I mean?
Okay.
I can have a hard time saying whether he's guilty or not. If I
Well-
see a car wreck, I know that car wreck, I saw a car wreck, but I don't know what the guy did. You can always say what he did.
Right.
To me.
Do you think that, kind of based on the same thing with the officer, you know, for an officer to make an arrest for something is a lower standard actually than what it takes to find someone guilty of a crime? Do you think that's fair?
An officer's doing his job and they arrest somebody, that's what he's there for.
Do you think an officer can make a right decision to make an arrest, but that someone can still be found not
He should be
guilty?
confident enough to do that, yeah, or he should be confident.
Well, what I'm asking, do you think that it's fair, or that an officer can be right to make a decision to arrest someone based on the information they had at the time, but that also that person can be found not guilty? Do you think that's possible that it can happen?
I guess, yes.
Okay, can you think of any examples of when that would be? Maybe there's more information that comes out later that they didn't have at the time, things like that? That's unfair? Okay. Anybody here disagree with that? Or understand, or agree with that? Have any thought either way? I'm gonna ask Mr. Kelly, do you have this one, sir? What do you think about that statement I made?
I think that if a police officer arrests someone, then they have enough proof from their standpoint to make that call. It's up to the judicial system to handle that from that point forward, to bring forward more proof for any other level.
Okay, thank you, sir. I'm gonna switch gears and ask you, sir, Mr. Smith? Okay. How would you determine, kind of in the getaway driver type situation that the prosecutor referenced, how would you determine whether or not the driver was a willing participant or not?
I think that's an improper question. They haven't heard the law on that, so we need to ask a different question.
Okay, along those same lines, what type of evidence would you like to hear in a case that involves a kidnapping? Would you like to hear witness testimony?
Yeah, or something that indicated that he was aware of what was going on.
Okay. And what other evidence would you expect to hear just generally in a criminal trial?
Witness testimony.
Sometimes photographs, fingerprints, things like that, kind of depends on the case. Okay. Could you pass that up please to Ms. Cook? Okay. Now, did I say that right? Are you Ms. Cook? Okay, I thought so. I'm gonna ask you the same question I kind of did generally about the police officers, but with the prosecutor. Do you think not just having that relationship, even if it was in the past, it would be difficult for you to say not guilty just knowing that the prosecutor's asking you to say otherwise? Would that be hard for you? Okay, thank you, ma'am. Now, I have another question for you. What are your thoughts on someone that has a criminal record? Let's say they testified as a witness in this case. How would you Or would you consider it at all? Would you consider it in terms of their credibility? If so, how much? Things like that.
If they were a criminal and haven't been prosecuted, or a criminal who has served his time?
Well, let's say, I'll be more specific. Let's say I was a witness in this case, and I took the stand, and it came out that I had previously had a robbery. So let's say I'm talking about what happened, this is what I observed, and it came out that in the past, I had had a robbery, I pled, did my time, but that was a part of my past. How would you consider that in terms of weighing credibility?
I would have to listen to what you said, because have you changed? Did your time served make a difference?
Sure. So you wouldn't automatically discredit what comes out of my mouth just because of that? Would anyone here have a hard time doing that, where they would, as soon as they hear it out, they're like, you know what, I don't think that I'm gonna believe much of what they say. You can be honest.
Okay.
Thank you. I appreciate your candor.
Well, I don't want to mention.
You're Miss Pence, right?
Yes, I do. My husband and I befriended a young man who went to juvenile court, and we had known him through a church group, but he did the crime and we visited him, blah, blah, blah. Then we bought him things because they can't afford to buy clothes and stuff. Well, then he gets out and then he does the exact same thing over again. Now, I'm not saying everybody's like that, but I don't know. That was the first thing that popped in my head when you said that. Would I be able to? I wouldn't want to think I would feel that way, but that did cross my mind.
Well,
So,
I think it matters too, like, if we were, just to take it out of that context, if we were here for a theft trial, let's say, because it stole some stuff, and the person gets up and says, well, I didn't take that candy bar, and we said, well, you know, you've taken 10 candy bars in the last 12 months. Sometimes the charge matters to, like, what they're talking about. Does that make sense?
yes.
But if I was saying something like, well, the sky is blue today, or was on that day, it wasn't raining, and it comes out, yes, I had a possession of drugs charge years ago. That's a little different. Is that fair?
Yeah.
Okay. Do you think that knowing what your experience with trusting someone that maybe was trying to help and that ended up, it sounds like they burned you a little bit.
Yeah.
As soon as you heard about that, do you think you have a hard time getting understanding of, or that would affect your credibility determination?
Well, I would never help that individual.
Sure, fair enough. But in this case, you know, if that doesn't happen.
I don't know, and so I hope I would be given the benefit of the doubt.
Okay, thank you. Let's move on, just because we're closest to ceiling. I'm asking the same question. What are your thoughts about all that?
I wouldn't have any problem with that.
You'd be able to listen to everything they say, not just, okay, that one thing, now I'm not. Okay,
Yes.
fair enough. Now, I'm gonna come back to the prosecutor asked you, I think, is there anything we should be concerned about, either the prosecutor or the defense, about being on the case? And most people said no, you said not really. What did you mean by that?
I'd like to think I'm pretty open and I can hear both sides and make a decision based on that.
Okay. So you meant, you were right, you would be a good juror, it sounds like. Okay. Thank you. Did you hand that over to Ms. Hart?
Yes.
Okay, let me catch up and grab your question here. Is there anything that I brought up about reasonable doubt, like not being sure, things like that? Do you have any questions about that?
No, I don't think so.
Okay. And do you understand kind of the principle I touched on, that it's not really an us versus them type of situation you're deciding, it's whether or not the prosecutor proved to you that Brandon committed a crime?
Yeah.
Are you okay with that?
Yeah.
Okay. And then like you said, you know, are you gonna feel comfortable voicing your opinions and all of that despite your age?
Yes, I would be.
Does anyone feel the opposite way? Like, oh, I feel as though I'm an older juror, so I should also listen to the other people. Anyone feel that way in the reverse? Okay, that's all I know. All right, thank you, Ms. Harden. Now, do you remember, are you Mr. Waters? Okay, sorry, I'm going off this handwritten, so I apologize. Mr. Waters?
It's Waters.
Waters, okay. So, sir, I wanted to talk a little bit about, do you understand that at the end of this case, the judge is going to give you instructions, and then you're going to look at the evidence that was presented from the witness stand, there may be some exhibits that are given in the back. Will you think you'll be able to make a decision on the evidence and not maybe like, well, I would have done something differently?
Yes.
Does that make sense?
Yeah.
And I'll use the example of something like, if you're here to decide a possession charge, or something that's separate, taking away from this case, and you heard that the person used foul language to a school teacher, something that they did that you didn't like. Does that make sense?
Yeah.
Would you be okay not making a verdict based on, well, I would have done something different, but on whether or not you believe the evidence you heard actually was a crime?
Yeah.
Does that make sense?
I think I would make a fair decision.
Okay. Because you guys are going to hear a lot of different things throughout this trial, and do you understand the difference between like, well, passing some judgment could involve criminal record, things like that, versus this is the evidence you're asked to
You
consider?
can't go on hearsay, you have to go on what's presented.
Okay. Does anyone else think they might have a problem with that? Well, I didn't really like that witness, but I think they were telling the truth, so that's what I'm going to find when I'm back there. Okay. All right, thank you, sir. Anything else I said? I'll go through everything that you wanted to comment on. Okay, thank you. Mr. Carter? What about you? Anything that I've touched on, some of these newer concepts that you have any comments or thoughts about as we're talking through it?
No.
Right. And all right, that's all I have. Thank you. We've got up in the Ma'am, have you ever heard the phrase guilty by association?
I have, but
What does that mean to you?
I'm not really sure.
It's hard.
It is.
Well, I'll talk about, you have 2 kids, right? 3, okay. Do they ever misbehave at your house?
Oh, yes.
Maybe just a few times?
Just a few.
Okay. It looks like they're pretty similar ages also. Okay. Is there ever a time like when you've walked in and seen, I don't know, a mess or something, even when they were little, and they're both standing there staring at you? How did you determine who to punish, who was in trouble, who was responsible? Like, what sort of things did you look for?
Well, they each have separate things, and goes into different things also. So I would know which, who's the things that was strung all over the place.
Right.
So I could tell, automatically who was guilty.
And like, let's say there's cookies or something, the one person had cookies on, the other didn't. That might help.
Well, you would just
decide who was
assume,
eating it.
yes,
Right.
yes.
So sometimes, even if you don't see something, you can look at facts, evidence, circumstances like that to kind of make your decision about who's culpable.
And it's the
Do
same
you
way
think you'll be able
on,
to do that here?
yeah, so it's the same way on the school bus.
Okay, oh, I'm sure. I should have asked that, honestly, I'm sure that happens every day.
Oh, yes, oh, yeah.
So, do you think that it's more important to punish everybody on the school bus for something that might have happened, or just the one that you really know you could prove?
Just the one that I know that I could prove.
Anybody here disagree with that? The whole bus is getting punished. No?
Now, if I really don't know who it was, then maybe, the whole bus will be quiet for the entire ride.
Okay. Do you understand how in this context that's not?
It's different, yes.
Okay. Thank you so much. The study? Is there anything I said that you thought was interesting or you had a comment about?
Not really.
Okay, anything you disagreed with? Like, something I said that, oh, that's absolutely wrong. Okay. All right, you pass that to the gentleman next to you. Mr. Roth?
Yes, ma'am.
Hi. Sir, what do you think about, actually, I'm gonna ask you about your prior jury experience. Do you think that, that experience and the finding that you made in that case, would that influence your decision here at all?
Well, since they're different cases, it's kind of hard to say that I would have any, or to, summarize them. If that's a word.
Well, and it just mean maybe if the instructions have changed or some of the laws might be different than what you were given when you were a juror, if it's a different crime, things like that. Would you be okay putting aside that prior experience and just listening to the evidence you hear in this case and then maybe the law of the judge?
I'd be good with what the judge has because all that stuff from the past, 15 years ago, is history.
Fair enough. That'll probably happen by tomorrow, honestly, on this case, so. All right, I think that's all I have. It is, thank you, sir. Mr. Ryan? Anything that I said that you thought was interesting or wanted to comment on?
No.
Okay. Same questions about witness credibility, be able to just listen to what they said, look at everything?
Sure.
Okay. And Mr. Pritchett? Same questions. Anything that came to mind as I was talking?
Yes, actually,
Okay.
when we referenced the other case about the murder, and the jury went home and did that little test.
Experiment.
Yes. Perhaps it's my ignorance, but I do not understand why that would be seen as something you shouldn't do, because that could prove guilt or innocence.
Well, I can answer that for you as a matter of law. The law prohibits a jury from trying to get evidence on their own. And if you have to decide the case you're selected based on what the evidence is and the law, and not as improper for any jury to go outside of the record and do things like look up things on their own, visit the scene, and I'll explain that when it comes to the jury that's selected. But that's a matter of law, because cases have to be decided what's actually admitted into the record. And yes, you're right, there may have been evidence that would make it relevant, but parties don't bring it in, we can't use it.
But could it be possible that the body being dry is evidence, and you need proof of?
Well, that's something that goes, I don't know, because I read about the case and I was aware of it, but it's a fundamental principle that a jury must decide the evidence, the case based upon the evidence that is admitted and nothing else. And so it is improper for the jury to go outside of the record during breaks or overnights, whatever, and do experiments or research and bring information to the jury room that was not admitted in the trial.
Okay.
So I'm gonna ask a follow-up question to that. Do you think, because I had this happen once, a juror, it was on a possession of marijuana case, which is illegal in Ohio. And that juror was like, you know what, no matter what I hear, I'm never gonna be able to say guilty because I disagree with that law. I don't think that that's right. I think it should be legalized in Ohio. So they weren't the best juror for that case. Do you think you'll be able to take the judge's instruction, not just the one he just gave you, but what's in there? And even if you have some questions and you're like, I really would have liked this, or I think this, make your decision on what's in those instructions.
I believe so.
And
Yes.
being thoughtful about it is obviously important, but to just follow the rules that they give you, they're important.
I understand, I believe so.
Okay, thank you, sir. Ms. Sanders,
Hi,
anything I said you would like to comment on?
no, I agree with what you said.
Okay. And anything about your questionnaire that would make you not be able to be fair and impartial to this?
Not a thing.
Okay. Thank you all for your time, I appreciate it. I'm finished on it.
Okay. Now, ladies and gentlemen, we're going to have attorneys come up here and talk to me. You're going to hear some static, and that's to make sure you don't hear what we're saying, because these matters have to be discussed with the counsel and the court to complete the jury selection. So if you would just remain at ease and be patient and remain quiet while we do this, it'll expedite things. So, counsel, if you would approach, please. All right, ladies and gentlemen, we have selected a jury, and I'll read off the list of jurors, and then some of you on this side have been selected. You'll be placed people over here. So I'll read those who have been excused. You may go ahead and exit out this way and go downstairs to the clerk's office to claim your voucher for reporting today. Number 2, Mr. Selden, you're excused. Number 3, Mr. Honeycutt, you're excused. Number 13, Mr. Fisher, you're excused. Number 14, Mr. Kelly, you're excused. All right, and let's do this easily. All right, so juror number 10, that'll be in the back. Mr. Sealing, you'll be in number 10, so if you would go back there by the door, take that seat. Miss Julia Hart, you'll be in the seat next to him, in the middle. Miss Pence, you'll be in number 2, on the front row, middle. Miss Fraser, you'll be on the end in the front row. Okay, so you 12 will be the jury, and then, since it's a one-day trial, we're only going to have one alternate, and the job of an alternate, it's kind of like being on the bench, backup quarterback, is that you'll sit through the trial and listen to everything, and unless something happens to one of the first 12, then you will not participate, you'll be excused, although you will be subject to being recalled if there's a problem during deliberation required the juror to be replaced, which is kind of like our insurance policy. So when that alternate will be Marcel Seth, and you'll just be able to stay where you're at during the trial. All right. So Mr. Hodson, if you would administer the oath to the jury. Now, before we do that, the remainder of the jurors, the prospective jurors that reported today, go ahead and move downstairs to the clerk's office and claim your voucher for appearance. We appreciate your appearing today. And Mr. Strain over at the admin building, hear me, go ahead and excuse all of those folks as well, and have them report to the clerk's office. All right, Ms. Rod, if you administer the oath to the jury, please.
Please rise. Raise your right hand. Do each of you swear or affirm that you will diligently inquire into and carefully deliberate all matters between the state of Ohio and Brandon, England? Do you swear or affirm you will do this to the best of your skill and understanding, without bias or prejudice, under the penalties of perjury, so help you God? If so, please answer, I do.
Thank you, Mr. Watson. All right, we are going to take a brief break here for about 15 minutes. I want to give you a few instructions before we do that. During the break, you're not to discuss this case in any way with any person, even among yourselves, and you're not permitted to allow anyone to discuss it in your presence. So if you're walking around the building or outside, if someone's talking about it, just walk away, or tell them you're on the jury and ask them not to discuss it. Don't speak with anyone that you've seen in the court here today at either counsel table or with anyone else about the case. You may go ahead and contact your loved ones or employers or anyone you might need to notify if you're being selected to the jury. When you do that, don't tell them anything about the case. Don't tell them who it is, what kind of case it is. Just tell them it's your own jury, it's a criminal case, and that's all you can say. And I'll explain that later in detail. But during the break, do not, like I said, you can make those calls. Now, you can go outside the building if you need to. I know if there's any smokers, you want to go outside and smoke outside, you may do that. There is a back of the, what I call the back of the building here, at the bottom by the door. There are vending machines that have soft drinks and snacks. There's also an elevator. If you go around this way, if you're having problems with stairs, you up and down that way. There's also a water fountain right through that back door, and also around this way to get back by the domestic relations area. There is a restroom in the jury room right there by Mr. Sealing, and the turn the light on there, and use the bathroom in there. I believe there's water back there. Is there any coffee? Water and coffee back there if you want to have some. If you want to get your own drink downstairs. And then there are also other restrooms on the first floor and also on the second floor. So it is now 10:08. So let's report back in your chairs where you're at 10. Won't take maybe about 12 minutes, and then we'll go ahead and get started then when we return. All right, thank you.
Please rise.
Yes.
Are you guys agreeing with the law? Water in here, that's soft drink?
Yeah.
Okay, thank you. I am parched.
All right.
Thank you.
Crazy weather. That's really easy weather. Of course, it's not over yet.
Never say never in Ohio, huh?
Probably have another blizzard here shortly.
Yeah.
Now that's why I brought our cushion. You do your cushion? You do yours. Like that, I'm wrong. Are you sure?
Just want to make sure I got all the jurors. So I'm going to call a juror number and just say yes, okay. Juror number 2, juror number 6, 7, 8, 9, 10, 11, 15. Okay. 16, 17, 18, 19, 22. So 15, Jen Smith. Somebody else. Just if you did, nowadays people trying to figure out who's there. It's raining out there.
I'm missing out.
This holiday, he did raise this up a little. Trouble is until on in the spring, it rains air conditioner. Until then, we have heat. So it's wonderful.
You know, it's not.
They fixed everything.
So it turns off now.
Oh, does it?
Yeah. Where it was just stuck on 90.
I wasn't sure who to turn this into.
I'm sorry.
I wasn't sure who to turn this into.
Oh, okay, okay. I'll give it back. I'll give it back.
That was it.
All right, we're back on record on Big High versus Brandon, Jonathan Abel. Remind everybody to turn off their cell phones again, please.
You shut that?
Okay, trying to keep windows open because our computer controls the heat in here, and it's always tough in spring when you have warm days and then cold days, and it doesn't change until a certain date, so it's a little warm in here, that's why I've got the windows open. So if anybody gets chilly, let us know. Lower it. All right, now, jury service may be strange to some of you, and so a short explanation is in order. Those who participate in a trial must do so in accordance with established rules. That's true of witnesses, the lawyers, and the judge, and also jurors. Now, lawyers will present the evidence according to the rules. The judge enforces those rules and determines what evidence may be admitted under them. Now, the jury will be the sole judges of the facts, the credibility of the witnesses, and the weight to be given to the testimony. And at the end of the trial, the court will instruct you regarding the law on that, and you will apply that law to the facts. Now, it's your sworn duty as jurors to accept the law as given to you by the court and to follow it. Now, the procedure for the trial will be as follows. First, counsel will outline what they expect the evidence to be. Opening statements of the attorneys are not evidence. They are a preview of claims of each party that are designed to help you follow the evidence as it's presented during the trial. After the opening statements, the state will offer its evidence. At the close of the state's evidence, the defendant may, but is not required, to offer evidence. If the defendant does present evidence, then the state may, but is not required, to present rebuttal evidence. Then the trial will conclude with the court giving instructions on the law, after the case, the closing arguments of counsel, and then instructions on deliberations by the court. And then after that, you will deliberate on your verdict. Now, the procedure for questioning witnesses is as follows. The party who calls the witness will ask the questions first. And that's called the direct examination. Then the opposing party asks questions, which is called cross-examination. Then the party that called that witness can ask additional questions after cross-examination only regarding matters that were testified to on the cross-examination. And that's called redirect examination. Now, in case you wonder, jurors are not permitted to ask questions. Now, during the trial, it's likely that attorneys will make what's called an objection. That is a procedure by which an attorney raises a legal issue that must be decided by the judge. Now, and just so you know, I don't make these rules up as I go and decide what this seat can be fair to me. I have, as I indicated, I have to follow the law just like you do, and there are certain rules of evidence and certain statutes that are adopted that are after the case, and that is what I use to decide whether or not the legal issue that's been raised is to be decided in favor of the party that objected, in which case it will be sustained, or if I deny that objection, which means overruled. Then that means that the question that was asked can be answered. Now, occasionally, an attorney will make an objection and the witness will give an answer before the objection is heard. And so sometimes when that happens, the court will be asked to strike the testimony, or I'll instruct you to disregard that testimony. So if testimony is stricken, it means you can't consider it. And at the close of the case, I'll also instruct you that you can't consider any evidence that was objected to, the objection was sustained. Now, I know we're not computers, we can't wipe the slate clean, but what that means is that during the deliberations of the jurors, somebody says, well, this witness said this when that case, when that question was objected to. You have to say yes, but we cannot consider it because that objection was sustained and we were told the testimony was stricken or we had to disregard. Now, it's important that you be fair and attentive throughout the trial. And as I've already indicated to you during breaks, you're not to discuss the matter with anyone else, even among yourself. Now, if you text or tweet or post on social media, you're not. You may do that during the trial, during breaks, but not about the trial. And don't permit anyone else to, if anybody else asks you anything in the form of a text or social media, do not respond to them. You're not to form or express any opinion on the case to anyone until the case is finally submitted to you. Because until we've heard all of the evidence and had all of the instructions of the law, closing arguments, you don't have everything that's required for you to make any decision. And that may be difficult to understand why you can't discuss it among yourselves. And again, things change. Sometimes we get impatient. In fact, that's one of my big beefs about all the 24/7 news coverage of legal cases is people will say, somebody gets a crime reported, somebody gets charged, and then the question is, do you think that person is guilty? Well, it's a terrible question because how can anyone determine it until you hear all the evidence? You're not going to hear it all on TV. You're not going to hear what the law is on TV in general because no one knows until the trial and the judge gives it to you. And so it's important that you not make any decision. It may make an impression on you. You may say to yourself, I want to remember that so when it comes time to deliberate, we can discuss it and see what it means. But don't make an early opinion about the matter. And again, it's improper for you to discuss it even among yourselves because, and again, until you've heard all of the evidence and had all the instructions of law, the arguments and opening statements, etc., you don't have everything that you need. Now, you must also explain that role to anyone else that you may come in contact with during the trial, during the breaks. And once the trial is over and you've completed your jury duty, then at that time you'll be released from this obligation. And you'll be permitted to answer questions and to talk about it with anyone. But until the case is completed and you're released, you're not to discuss the case or your experiences as a juror in any way with anyone during the pendency of the case. And like I said, if you're asked about it at lunchtime, or on the phone, or whatever, just tell them, look, I can't discuss that. That's why I tell people, don't even tell them who's involved, because somebody might inadvertently blurt something out. And the reason for that is the folks that you're communicating with aren't under the obligation you are. You've taken an obligation to follow the law and decide the case based upon the evidence fairly and partially. And they have. And that doesn't mean they're bad people, it just means they don't understand the obligation you've taken. They haven't heard all these instructions. Now, as we talked about a little bit more here, you're not to investigate or attempt to obtain any additional information on this case outside of the courtroom. It's highly improper for anyone on the jury to do so. So that means you can't, I don't know if you'll hear about the scene, I assume we will, you're not to visit that place, you're not to try to go in and research anything on the internet, because you may hear something about, well, here's a term I heard in the testimony, nobody's really explained that. I want to know more about that. So, with the internet today, we go online and get Wikipedia. Now, whether it's accurate or not, who knows, but, there'll be some information on there. Well, that's the kind of thing I'm talking about. You're not permitted to do that. You're not permitted to read anything about the case, review anything about the case, whether it be in a newspaper or online or in any social media postings, nor may you listen to any report or view any report on TV or listen to it on radio or internet broadcasts, podcasts, etc. if there are any. And you're not permitted anyone to read anything or give you any information on anything that has been in any of those sources. News reporters are persons who post information about a trial online, again, are not under the obligation that you are. They often don't hear the entire case and hear snippets of it. Furthermore, those folks are not sworn to do the jury, which is to fairly and impartially try this case based on the evidence of the law and render a very impartial verdict. Particularly news reporters or people that are posting, they want to get something out there that they think will get attention and get people to read it and respond. Their purpose is, and again, I'm not saying that's bad, but it's not what we're here for. We're here to follow the law and decide the case in accordance with the rules that I've given. Now, if by chance you should have somebody say something to you inadvertently, or see something or read something about the case inadvertently, report it to the bailiff, and then I'll discuss it with the attorneys and see what needs to be done, if anything. But don't report it back to your fellow jurors. So like during a break or during lunch, which would be your longest break, something like that happens, don't come back to the courthouse and then say, I think I thought I would say something, but I'm not sure, so I'll ask some of the other folks in the jury. If you do that, that means that, because we may have to ask you questions if that happens, and if you have discussed it with your fellow jurors, then we'll have to ask all of them questions. And about 20 years ago, when I was a prosecutor, we had a trial of several days. We had, I think, 12, I know we had 12 jurors and I think 2 or 3 elders, and that happened. We spent the afternoon bringing each juror in and asking them questions about what they heard, and what impact, if any, it had upon them, and whether or not they could continue to serve on the jury. And so we wasted a whole afternoon simply because of that. So that's why I tell people, if you got any questions, don't bring it up to anybody but the bailiff, and the bailiff will report it to me. Since this is a trial of short duration, I don't allow notes, because I believe that it distracts people from hearing what's important. And maybe that's my opinion based on my own experience, and I'll give you an example. A long, long time ago, I was a freshman at Ohio State. Graduated from Hillsborough, went up there, scared to death in the first class. I was writing down everything that the professor said. His name, his phone number, his office number, and everything that he was saying. I only remember what class it was. And as I'm writing it all down, and I know I'm behind, I realized now he's starting to say stuff that sounds important and I'm not getting it. And so it took me a while to learn to listen and write. My handwriting suffered terribly, but again, you have to kind of do that to survive. But so I don't want you to do that, because the other thing is, it's human nature. If you're taking notes, you start taking notes at the beginning, writing everything down like I did, and then later on you realize, well, it worked, and I wasted a lot of time. So I just do that to prevent any distractions. And again, this is a short trial, so I think that note taking is necessary. All right, now, as you have noticed when we selected the jury, on time we'll have a conference up here, bench called bench conference, and during that time the static will be turned on, because at that point the attorneys may be discussing with me an objection that was raised that we need to discuss, or they may have some logistical issue, some other legal issue that we need to discuss. And so, for instance, if there's an objection and the party wants to argue, the attorney wants to put on some information on the record to argue that. If you listen to all that, then I decided you shouldn't hear it, and I said disregard it, that just puts a bigger burden on you to forget stuff or not use stuff when you shouldn't. So that's one of the reasons we do it that way, so that it's being recorded, it's not being, you're not going to hear it. And then if I ultimately decide, no, it's not permitted, then it's something that you don't have to work but forget it. Okay, I believe that completes the instructions. Again, I'm trying to do a very great job to talk with the attorneys or any witnesses or anybody that's at the council table or any spectators about or any other person about the case. Now, this time we'll hear opening statements of counsel. Opening statements are not evidence, as I've indicated earlier. They're simply each attorney's preview, if you will, of what they believe that the evidence will be as it comes out. And they're designed to help you follow that evidence as it's introduced, but it is there not evidence. Mr. Collins, may I have your statement?
May it please the court, Ms. Deardoff. Ladies and gentlemen of the jury, today I will present the evidence and testimony to prove that on August the 30th, 2018, Brandon Engel and Brandon McComas worked together to physically assault, kidnap, and finally rob Dustin Hunter. On August 30th, 2018, Brandon Engel and Brandon McComas made contact with Dustin Hunter and asked Dustin to give them a ride. Dustin Hunter knew Brandon Engel from high school, and it met Brandon McComas through Brandon Engel, just within a couple weeks recent to August 30th of 2018. After the promise of $40 for gas, Dustin agreed and drove to Eastgate to pick the pair up. As he was driving back to Highland County, Dustin was instructed to stop at a church. Now, once at the church, Brandon McComas ordered him to give them his stuff. And it'll come out that he was talking about some speakers and some Oakley sunglasses and some other random things that Dustin Hunter had in his car. Dustin Hunter refused, and when he refused, McComas began to strangle Dustin with his seatbelt and beat him about the head. Dustin tried to fight back, and McComas bit Dustin on the chest. Dustin was then instructed to drive again and to stop a short time later. At this stop, Dustin tried to run, and McComas tackled him. McComas again beat Dustin and ordered him into the back seat of the car. It was at this stop that Cheyenne Vollmer, who was driving by, she was headed to Walmart and had her children with her, actually saw two men standing over another man laying on the ground and heard the man on the ground yelling for help. Now, Cheyenne had her two young children in the car with her, and she was afraid to stop, but she did call the sheriff's office and advised them of what she saw. Now, the man on the ground was Dustin Hunter, and the two standing over him, Brandon Engel and Brandon McComas. At this point, Dustin Hunter is ordered into the back seat of the car, where Brandon McComas is also. Brandon and Dustin are now in the back seat of the car. The driver of the vehicle at this point, the defendant, Brandon Engel. Brandon Engel continues to drive the vehicle into Hillsboro as McComas is in the back seat beating Dustin mercilessly. Now, when I say mercilessly, there are pictures of this. He severe bruising, severe knots, blood, knocked all over his head. He lost consciousness. He vomited all over himself and all over the backseat of the car. All of this you can see in the pictures. And the entire time, he's asking for help. The defendant drove the vehicle with McComas and the victim, Dustin Hunter, in the back seat to Spiegel Street in Hillsboro. Once they got to Spiegel Street in Hillsboro, the two gathered up everything they could carry. They left Dustin in the car and they took off. Dustin feels he must have been unconscious at the point, but he realizes that there's nobody around, gets a minute to gather himself, and gets out of the car to try to get help, and eventually is able to get the police department and the sheriff's office to respond, as well as an ambulance. Paint Creek Fire District responds, and they take him by ambulance to Highland District Hospital. Ladies and gentlemen, when Brandon Engel got into the driver's seat of that vehicle, and he and McComas forced Dustin Hunter into the back seat of that vehicle, they were effectively kidnapping him at that point. They were restraining his liberty. He was trying to run away, and they were keeping him from doing that. When McComas repeatedly beat Hunter on the way to Hillsboro while this defendant drove with that going on in the back seat, drove to Spiegel Street where Engel and McComas gathered up all they could carry and took off, they robbed Dustin Hunter. Everything the one did, the other was equally responsible for. As such, Brandon Engel is guilty of kidnapping, and he is guilty of robbery. And at the end of the evidence and testimony, I will ask you to find him guilty and hold him responsible for what can only be described as torture that Dustin Hunter went through. Thank you.
You're over to have it.
Thank you, Judge. When I thought about what to speak to you about today's opening statement, the phrase that came to mind is the devil is in the details. This situation, you're gonna hear much more than what the prosecutor just said. It really begins on August 29th, 2018, because that's when Brandon asked Dustin for a ride, paid him for the ride, and then they went to IHOP, and Brandon bought him a steak. These types of details is what you'll hear from what my client did that over the course of those 2 days. Asked him for a ride, paid him for a ride, never took any of his stuff out of the car at that point, the day before these allegations. Now, on August 30th, it was actually Dustin who reached out to Brandon because McComas had taken belongings from Dustin's vehicle the day before. Brandon helped him get those belongings back. He called him back and said, "Bring him over, come on over here, I'll make Brandon give it back to you," which he did. When Dustin drove there to get his belongings, they asked for a ride. And actually, McComas asked for a ride. He said, "I want to go to a party in Hillsborough. I'd like to bring Brandon Engel. Can we have a ride? I know Brandon paid you yesterday." Dustin went back and forth about that, didn't seem to want to drive him, he had somewhere to go. Brandon McComas was insistent, so he agreed. And my client paid Dustin $40 for that ride. At that point, they're on their way to Hillsborough, and Brandon McComas, alone, acting alone, from the back seat, says, "Pull over. We're going to walk from here." Brandon Engel's never been to where they're going, so he gets out of the car and starts walking. At that point, after Brandon has left the car, is when McComas starts assaulting Dustin. The two of them go back and forth. Brandon starts to see the fight and starts to run away. At that point, and this is according to the victim, he yells for Brandon because they're friends. They've known each other since high school. So Brandon stops and goes back. He says something to the effect of, "Get the F off of him, dude. Stop." Not something that you really hear from a listener. They do get back in the vehicle. Brandon McComas says, "Let's drive to our destination." So Dustin continues to drive. At a certain point on this second drive, Dustin runs his car off the road to try to get out and run. Brandon McComas, alone, chases him. You will not hear evidence that he touched Dustin, that he threatened him, that he encouraged McComas to do anything. And you'll hear about the scene of where this car was run off before this Cheyenne drove by. It's pitch black on a rural road, late at night, with no businesses, no homes, nothing around. The two of them, Dustin and McComas, fight mutually. Dustin fights back with the men. When they get back in the car, Brandon is ordered to drive, get them out of there. He was terrified of McComas, who went crazy in the vehicle. You'll hear about that. There is no doubt, you will not hear any dispute from either side that Dustin Hunter is a victim, and that McComas assaulted him and robbed him. That's not in dispute at all. The only act that you're going to hear the prosecutor get up and ask you to find him guilty of is a short drive. That's it. You'll hear that actually when he was driving, McComas continues to threaten Dustin, and Brandon is saying, "Stop. Don't do it. Stop, dude. Stop." It isn't until the drive ends that then Dustin is free. The prosecutor wants you to believe that these two were acting in concert together, and just because Brandon didn't punch him or actually take a piece of property, he's just as guilty. But I want you to listen to the evidence that comes out and hear in the details what Brandon was doing, but also what he wasn't doing, what he was saying and what he wasn't saying. You will not hear one statement that he ever encouraged him, participated in this. He didn't even just remain silent. He said, "Stop, dude, you're hurting them." In this quick moment of two people fighting, a scene that escalates, him driving them out of this ditch for half a mile, doesn't take any of his property out of the car, doesn't get anything out of this, Is that the behavior from somebody that's gonna pay someone a ride for a ride the day before? Is that someone that's guilty of kidnapping? And I agree wholeheartedly with the prosecutor, that if this was something where Angle gets in the front seat, my client, and says, "Where to? Let's take him, get his stuff, give him everything." He absolutely is guilty of kidnapping. He absolutely is guilty of robbery. But that's not what happened in this case. Any act taken by Brandon was in response to an insane situation that was created only by Brandon McComas. He's the only person that did anything. And to suggest that, like I said, driving a short period of time and then that ended it so Dustin could call 911 is complicit, I don't believe that you'll be convinced at the end. But what's more importantly is what the law says, which is that for him to be found guilty, they have to prove to you that he knowingly aided and abetted. And I do not believe that at the end of this, they will have done so. So I ask you to listen to the details, because it matters. What was happening in the car, what he said, what McComas did, but more significantly, what he did not do. And ask yourselves, would I have done different? Maybe. Maybe not. And at the end of this trial, we're going to come back and I'll have an opportunity to speak to you one more time and we'll ask that you find him not guilty. Thank you.
All right, stage first witness.
Dustin Hunter?
Or motion separation.
Yes, Your Honor.
All right, all those who expect to testify, other than the state representative, will be required to remain outside the building. Testimony.
Come over here, please. Face against your cross, please.
Would you raise your right hand and be sworn, please? You solemnly swear that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you.
Yes, Your Honor.
All right, we'll run past it on YouTube. You carry the camera, show your face.
That's okay.
Sorry.
Yes.
Maybe have a seat right there. Yes, and pull that microphone over front of you, please. And you may take the mask down while you're speaking. Make sure your phone's off if you have it on. Thank you.
Good morning, Mr. Hunter. Can you please state your name for the record?
Dustin Davis Hunter.
And can you spell your first and last name?
DUSTENHUNTER.
And are you currently employed?
Yes, I work at a Mayor.
You work where?
I work at a Mayor's insurance company.
And what kind of work do you do?
I do information technology.
Have you been to Highland County before today?
No.
When was the first time that you were in Highland County?
I believe it would be the night of this.
Does August 30th of 2018 sound correct?
It does.
Are you familiar with Brandon Eagle?
Yes.
And how are you familiar with him?
He's a high school friend.
Do you see Brandon Eagle in the courtroom today?
Yes, sir. Yes.
And where do you see him?
Sitting across the way.
Can you point it out, please?
Yes.
Please let the record reflect the witness identify the defendant.
Yes, yeah.
Are you also familiar with Brandon McComas?
Briefly, I met him once.
And how did you meet him?
Through Brandon.
I'm going to take you back to August 30th of 2018. Did you meet up with Brandon Eagle and Brandon McComas?
Yes, I was getting equipment that they had in my car, some batteries for a drive.
You would lean a little closer,
Yeah.
Speak a little louder, please, make sure the jury can hear you.
I was retrieving some items from my vehicle that were taken from vehicles, batteries.
Okay, so you met with Brandon Eagle and Brandon McComas to get batteries
To
back?
retrieve batteries, yes.
Okay. And did one of them or both of them ask you to give them a ride?
I believe Brandon McComas, asked to give him a ride to his sister's house.
Were they both going?
They were both there. I'm sorry, I didn't hear the question like that.
Were they both going wherever?
Oh, yes, they were both going to his sister's house.
Did you agree to give them a ride?
Reluctantly, yes.
Did they agree to give you money for this ride?
Not that I ever recall.
Did you receive any money from either of them?
No.
Where did you pick up the two of them?
I believe it was Mr. McComas' grandmother's house.
And where's that at?
In Amelia, or I believe it was in Beachmont area.
Okay. So you're coming from the Beachmont, Eastgate area to Hillsborough, is that correct?
Yes, ma'am.
Okay.
Yes, ma'am.
Where was Brandon Eagles sitting in the vehicle as you were driving?
I believe Brandon was in the passenger seat, and
Where was Brandon McComas sitting?
Mr. McComas was behind me in the back seat.
What kind of vehicle were you driving?
It was a 2008 Mazda 6.
Is that a two-door car or a four-door car?
Sorry, four-door car.
Now, at some point, were you instructed to turn onto a side road?
Yes, as we were heading down a back road, I was instructed to turn off this main road to a back road. I'm not familiar with the road.
Would that have been around Danville?
I'm not sure.
Okay. Once you were on this back road, were you instructed to pull over?
Yes, I got to a point, I believe it was an old abandoned church, but I guess I was told to pull over off the road.
And what happened at that point?
I was instructed to hand him the stuff that I had and to get out of the vehicle, and I resisted.
And what happened when you resisted?
I just remember being held in to the driver's seat with a seatbelt, and pulling Mr. McComas over top of me and him biting me. And then I believe I got out of the vehicle at that point.
Well, at some point, did you start driving again?
Yes, after I got out, they instructed me to get back in the vehicle and start driving the vehicle again. Yeah.
Okay. And at this point, do you know if you were on US 50?
I remember there being a lot of cars passing us. I'm not familiar with the road.
Were you still headed toward Hillsborough?
Yes, we were still heading in the same direction.
And were you being given directions on where to drive?
Yes, yes.
At some point as you're traveling, were you instructed to stop the vehicle again?
No, I actually jumped out of the vehicle, I believe, or I stopped and got out and was running away. And I think that's when I was being chased down, and I believe a car stopped. I was trying to flag them down.
Now, as you were chased down, what happened next?
I remember being in the grass and Mr. McComas hitting me. I remember Mr. Engel getting into the driver's seat, and then Mr. McComas forcing me back into the back seat of the vehicle.
Okay. Now, as you mentioned that you saw a lot of cars going by. As you saw cars, or as you saw headlights, did you hear Mr. Engel say anything to Mr. McComas about the vehicles?
I don't recall now.
Once you were ordered into the back seat of the vehicle, who was driving the vehicle?
At that point, I believe I was in the back seat, and I believe Mr. Engel was driving the vehicle, and Mr. Cohen was in the passenger seat.
Was he continuing to hit you?
Nobody was threatening me to stay down and to not get out again, and that he would hit me. That's all I recall with that. Yep.
Did you lose consciousness when you were in the backseat of the vehicle?
I do remember coming to, so yeah, I believe I lost consciousness, but I remember puking and coming to, and I think I had my watch on my wrist, and he noticed that I had that, and he asked me to take it off. I believe I do remember that. So yeah, I'm pretty sure that I came to, and in the back seat.
Now, at any point, did you hear Mr. McComas threaten Mr. Engel?
Not that I recall.
Did you see Mr. McComas hit Mr. Engel?
Not that I'm aware of, no. I don't think that.
Were you hit with a weapon at any point?
I was hit with one object, a speaker.
When you got to Hillsborough, do you remember seeing anything?
I remember passing some restaurants, a Wendy's, maybe an apartment complex.
Okay. When you were at the apartment complex, what happened?
I remember I was in the back seat, and I was looking out the window at that point to see where we were at, and I remember Mr. Cummins telling me that if I got out, nobody was going to help me, or something specifically like that. I just remember that him saying something about if I got out, nobody would help me.
Eventually, did the vehicle stop someplace?
Yeah, I remember I was in the back seat, and we were just on some random back road somewhere, and I got up and they both were gone. Brandon and both Brandons were gone, and I just remember going to a neighbor's house and asking them for help.
So let's.
I'm sorry.
Go ahead.
No, I just remember exiting the vehicle and asking for help.
When you approached a neighbor, like a door at someone's house?
Yeah, it was a couple doors down from where the vehicle was at.
Okay. And who arrived on the scene? Was it?
It was paramedics and officers.
Okay. At some point, were you able to look in the vehicle and notice if anything was missing?
The next day, when the officers showed me all the vehicle.
Okay, and what did you notice was missing, if anything?
Just some small items like some sunglasses, the speaker, and some smaller odds and ends. It wasn't nothing major vehicle.
But
nothing.
Were they items that you had given someone permission to take? How many times did you try to run away from Brandon McComas and Brandon Engel prior to stopping the vehicle and then leaving?
Your Honor, I object to the characterization. I would just ask that she ask for each Brandon to clarify the jury.
They were together in the same vehicle.
So, how were you asking the question?
How many times did you try to run away from Brandon Engel and Brandon McComas? Escape that vehicle?
I believe it was at least twice that I
Did you ask? Did you ask them to stop beating on you?
Yes, I remember yelling for Brandon Engel and McComas.
Did Brandon Engel assist you? Did he help you?
No.
Were you taken to the hospital?
Yes, directly after.
May I approach the witness line?
No.
Going to hand you what's previously been marked as State Exhibit 1 for identification purposes. Do you recognize that?
Yes.
What is that?
This is my medical record.
Are those a certified copy of your medical records from the hospital?
Yes.
And are those the records you received for your treatment at Highland District Hospital?
Yes, they are.
How long were you in? How long were you in the hospital?
For a good couple hours. I'm not exactly sure the timing.
Okay. And after you were in the hospital, did you have to miss work?
Yes, I was out of work for a couple of days. At that time, I wasn't working in the office, so my face was pretty messed up.
So you couldn't go into
I
work?
couldn't physically go in.
Okay. Can you just lay those down before us once? May I approach the witness?
May.
Getting into its previously been marked as State Exhibit 7 for identification purposes. Do you recognize that?
I don't recognize the piece of clothing, but I do recognize that this is my vehicle. Picture.
So that piece of clothing, you recognize that to be laying next to your vehicle?
Yes, I do.
I hand you what's previously been marked as State Exhibit 9 for identification purposes. Do you recognize that?
Yes, I do. It's me in the hospital.
And is that a picture of your face?
Yeah, it's a picture of my face.
Next, going to hand you what's previously been marked as State Exhibit 10 for identification purposes. Do you recognize that?
Yes, I do. It's a picture of my face.
And does that depict the knots that are on your head and face?
Yes.
Next, I hand you what's previously been marked as State Exhibit 11 for identification purposes. Do you recognize that?
Yeah, it's a bite mark on my chest.
And where did you get that bite mark from?
It was from Mr. McComas biting me.
Next, I hand you what's previously been marked as State Exhibit 14 for identification purposes. Do you recognize that?
Yeah, it's a picture of some scratches on my back.
You said that when you, at one point, were stopped and, you saw a car stop or slow down. Is that what you said?
Yeah, I remember there was a car that stopped, did not fully, but stopped, and I was, back waiting, and I was asking for help. Running when I was running.
As the car stopped or slowed down, did you hear Mr. Engel say anything to Mr. McComas about that?
I don't recall.
I have no further questions.
Josh?
Thank you, Larry.
Justin, my name's Alex Theodore. I just have a few questions for you, okay? So you know Brandon Engel from high school, correct?
Yes.
Right.
From friends.
And you guys have also, you kind of grew up together, I think you lived in the same
We live in the
neighborhood.
same area.
So you've known him for years. Is that fair to say?
Yes.
And never had any issues with him, correct?
Prior, besides high school stuff.
And before, not this night, the night before this happened, do you remember giving Brandon a ride?
Yeah, it was the night before. It's actually how the bad news came into place.
So, and Brandon paid you to give him a ride, right?
I'm guessing, I don't recall exactly the money.
If you told the police he paid you $25, does that sound familiar?
It does.
And then at some point you also went to IHOP that night. Do you remember that?
I don't recall, 'cause I mean, it's just been so long, I don't know.
I understand.
Sorry.
It's been a while, but do you remember telling police that you guys actually went to IHOP and Brandon McComas was there too?
I don't recall that.
Okay. Do you remember giving an interview to police on August 31st, 2018?
After this.
The day after?
Yeah, yes, I do remember talking to police.
Okay. If I handed you a transcript of that interview, would that refresh your recollection about what you may have said?
Yeah.
Okay. Can you just take a look at page 2 and read the intro comments just to make sure that refreshes your recollection?
You're not gonna object.
Well,
I've never seen this, I don't know if it's accurate or not.
oh, you have to disclose this?
No.
I'm happy to give that, I brought an extra copy of it.
Let me see if we can, the document.
Your Honor, I'm not admitting it, I'm just using it to refresh your recollection.
All right, you may get back.
Just take a look at the first 2 pages, just to make sure that that's the winner that you gave it.
I guess reframe your question, or re-ask your question, because I guess I'm confused. Because this is, to me, this is what the officer, I was telling the officer.
Right.
The day after.
Right. I'm just asking, do you remember talking to police the next day?
I do.
Okay.
I do, and then most of this makes sense, it's
It's been a
hard to
while, I'm
understand.
sure.
Yeah.
Okay, I'll take that back. So if you told police that you guys went to IHOP and Brandon bought you a steak, does that sound familiar?
Possibly, yeah.
Okay.
Yeah.
And then the next day is when you picked up Brandon and Brandon McComas to take them on this ride to Hillsborough. Does that sound familiar?
Well, I rephrase it. Well, I didn't pick them up. I was trying to retrieve my bags.
Okay.
And,
I'm sorry, you're gonna speak up.
my bad, sorry.
You're trying to retrieve what?
I was trying to retrieve my batteries, so I wasn't picking them up.
Do you remember calling, though, Brandon Angle looking for some items?
I did call
And then he called you back and said, come over and I'll give you the bag?
Yes.
That Brandon McComas had taken out of your vehicle?
Yes.
Okay. So, and do you remember telling police that Brandon Angle brought you the bag out, and then McComas actually got in your car and said, can you give me a ride to my sister's? And you said, get out.
Yeah, I do remember them forcing, really wanting the ride, and Brandon McComas did get in my vehicle.
Okay. You're saying them, but do you remember saying Brandon McComas insisted when you told police? You didn't say them.
They were both pretty insistent, but you're right. They were insistent on getting in the vehicle.
Okay.
For me to give them a ride, and I told them I had stuff to do, that I had plans.
And they offered to give you some money to go to this party in Hillsborough.
I don't remember them offering me money, but I do remember them, really wanting me to give them a ride, and they would not take no for an answer.
Okay, but on the way over there, Brandon McComas was the one that was giving you directions to this party. Do you remember telling police that?
I do remember him giving me directions.
Okay. And you said that 90% of the ride, it was fine, there were no issues.
It's very quiet, yes.
Okay. And it was Brandon McComas that told you pull over at the church so that they could walk.
Yeah, he did tell me to pull over.
Okay. And do you remember, as soon as you pulled over, Brandon Engel actually got out of the car right away and started walking. Do you remember telling police that?
I do not recall that.
Okay. Do you remember writing out a statement? Like an affidavit is what it's called?
Yeah, I remember writing something.
Your Honor, may I approach?
No.
I'm going to hand you this document. Is that look familiar?
Do I want to hand her in? Yes, it does.
Okay.
Keep your voice up. Yes, it does.
Okay. And on page 2, after the church, do you remember writing, Brandon Engel got out of the vehicle and walked away? Should be like middle of the page down.
I'm honestly sorry, I can barely read my own writing. Oh, okay. Yes.
Remember, do you see where it says Brandon Engel?
Yeah, I do see it. Yes, I do.
Okay. So, Brandon McComas tells you to pull over, that they're gonna walk. And then, when you pull over and stop, Brandon Engel gets out of the car. Okay? Do you remember writing that in your sworn statement?
I don't recall it, but clearly it was written down. So.
And you gave this statement on August 31st, 2018, like right after this happened, right? Okay. And it wasn't until, so after Brandon Engel's out of the car, that's when Brandon McComas says to you to hand him his sunglasses, your sunglasses and wallet, and hit you in the face. Do you remember that? Writing that?
I don't remember writing it, but I do remember the events, and maybe it wasn't exactly like I wrote down, because that doesn't, from the way I recall, is we were in the vehicle when he asked for the sunglasses.
Keep your voice up.
Sorry.
Well, sir, to be fair, you did give that you wrote this for the police to use the day after this happened, when it was fresh in your memory, right?
Yeah, you're right.
And you wrote, Brandon got out of the passenger seat. And then Brandon Engel told me to hand him my sunglasses and wallet. Do you remember writing that?
I don't recall writing it.
Okay. And that's when he started to assault you with the seatbelt in that vehicle, right?
He did assault me with the seatbelt, but maybe not in that order.
That's the order you wrote, correct?
Yeah, I'm guessing so, yes, you're right.
Okay. Now, at another point, then Brandon Engel got back in the vehicle and you were still driving to the next spot, right?
Yeah, at one point, yes, I was still driving. I was told to get back in the vehicle.
Okay. And that's when you tried to jump out of the car, right?
There was a point where I slammed the brakes, I tried to get out and run, and I got tackled down.
Okay. And that was by Brandon McComas, correct?
It was Brandon McComas jumping me, yes.
Right. And at no point did Brandon Engel tackle you or assault you in any way, right?
No.
Okay. And he did not threaten you or use any of the vehicle devices to restrain you, correct?
No.
And you did also say to police that you were pulling on McComas's hoodie. I was trying to hit him, so you're trying to fight back, right?
So in that particular scenario, he was strangling me with the seatbelt, and when I pulled him over top of me, he bit me in the chest, and that's how I got out of the vehicle the very first time.
Okay. So you were trying to defend yourself, is that fair to say?
I was trying to get him off of me, yes, defend myself, yeah.
Would you agree that his behavior to you was extremely violent and erratic?
Yes, I agree.
And for 90% of the ride, everything was fine, and then he decides to tell you to pull over, and things got out of control. right?
Yeah.
Okay. Do you remember telling police at some point when Brandon was driving that Brandon McComas talked about a gun, that he would shoot your mom? If you told anyone?
I don't recall. I mean, I know that they were threatening me because I got out a couple times, so I don't recall the exact threat.
Do you remember, though, telling police that Brandon McComas talked about having a gun and that he would use it on you when you were still in that car? Whether or not you saw one, do you remember that?
I mean, I remember him threatening me a lot. So.
Okay. So it's possible that you told police that he was threatening you with a gun and to shoot you if you got out or did anything?
It's possible.
Okay. And the police asked you what they were wearing, and you told them you could only remember McComas because he's the one that was hitting and fighting you. Do you remember that?
Yeah, he was on top of me most of the time, so yeah, right, I do remember that.
Okay. Do you remember also, at one point you told police, I was screaming for Brandon Angle because I know him from school. Do you remember that?
I do remember saying.
So you were calling out for help from him. At this point, he's not involved. You're looking for help from him.
I was asking for help.
Okay. And then Brandon Angle at one point yelled at McComas. You told police, dude, get off of him. Dude, get off of him. You're going to hurt him. Do you remember telling police that?
I don't recall saying that.
I'm going to approach again with the transcript.
Your Honor, can we approach?
Okay.
Okay. I'm going to show you, I'm going to direct your attention to page 14. Okay. Do you remember the Deputy Alexander asking if you were screaming or yelling? You can read that. Take a moment to read that page. I know it's been a while. Does that refresh your recollection, sir, of that interview?
Yeah, it does.
Okay. And so do you remember then telling police that you were screaming for Brandon Angle, and at that point you yelled, dude, get off of him, you're going to hurt him?
I don't remember exactly saying that, but I do remember Brandon McComas being on top of me, and the part where it says Brandon Eagle wasn't necessarily around, right? And I just remember hearing Brandon's voice.
Okay.
I do remember hearing Brandon's voice while I was being paid.
Okay. And so is it possible, based on what you told police, that he was telling Brandon McComas to stop?
I mean, it's possible.
Okay. And if you go to page 44, I know I briefly touched on this with the gun, but I just want to see if this refreshes your recollection of the conversation you had with the deputy. Do you have an opportunity to read that page?
Yeah,
So do you remember Brandon McComas talking about a gun?
yeah, I mean, not specifically saying, you know, I'm going to shoot you, but I do remember him referencing that he was gonna hurt, you know, a family with a gun or something like that.
Okay. And you didn't see one, but you remember him saying that.
I did not see that.
And at that point again, do you remember Brandon Angle telling him, don't do it?
I don't necessarily recall that now, but I do remember it now.
So it's possible that you don't remember it today, but that you did tell police that back in 2018.
It's definitely possible.
Now, I don't have too many more questions, but is it fair to say you telling Brandon McComas to stop didn't stop him?
Yeah.
And I know that's an obvious question, but did you tell him multiple times to stop what he was doing?
Yeah, and I asked him to stop.
Okay. Did he stop? Did he stop?
I mean, enough to get me back into the vehicle, so, you know.
Okay. So when you get put back in the car at that last final stretch, he had stopped at that point?
Yeah.
Okay. So when Brandon was driving, you're in the back seat, there's no more assault taking place?
I possibly never saying.
And it wasn't until you got to the final place where the car was stopped that you were able to get out and call for help, right?
Yeah.
And you were able to call 911 from your cell phone, correct?
I actually got to a neighbor's house and was banging on the door. They called the police.
Okay. Was the house close to the vehicle that you?
I would say 100 yards.
Okay. Was the car kind of in the middle of the road actually? Like it wasn't
was
parked in a parking space?
It was in the road, a dead end road.
But in the road?
Yeah, it was in the deep road.
Okay. And your phone was not taken though, right?
But no.
If you were able to pull up on your phone in hospital, you're showing the police, I think, some maps. Does that sound right?
Yeah, I remember that.
Okay. When you were unconscious, or I guess when you were in the back seat, as soon as the car stopped, were you awake or not awake?
I remember being awake or coming to and them not being there. So I believe I was passed out at that point when the car stopped.
Okay. And I just have to ask, and I'm not sure if you were conscious or not, do you remember Brandon Angle telling Brandon McComas to leave his phone?
Objection.
I don't remember that. You don't have to answer that. Sorry.
So are you not able to testify about any of the conversations that may have taken place after the car was stopped at that last resting place?
No.
Do you remember the police, they kind of come back and ask you some details about, because you were saying Brandon a lot in the interview, so they say, who did what? Do you remember them kind of asking you that, like to find who bit you, things like that?
Yes.
And the officer said, who bit you? And you said Brandon McComas. Do you remember that? And then the officer said, it sounds like McComas did, and you interrupted and said, he did all of it. Do you remember that?
I don't remember that those exact words, but I do remember talking to them about, you know, being hit by Brandon.
Okay. And at no point did Brandon Angle tell you to give him any of your belongings, correct?
Objection.
Cases? Go ahead, sir.
I'm not aware of that. I don't recall that.
Just 1 minute, sir, thank you. Just 1 minute, Your Honor. I have no further questions, Judge.
Wait, right.
Thank you. Mayor Coach.
Mr. Mark, I noted that on page 2 of your affidavit that you said Brandon Eagle got out of the car and started to walk away. Can you show me where it says that on there?
Pastor C.
It's fair to say it doesn't say that, does it?
Exactly.
Yeah, not even.
It doesn't say walk away, it just says Brandon Eagle got out of the pastor's seat.
Right. So it doesn't say that he walked away.
It does not. That's my wonderful handwriting.
Now, there are several things that she asked you that you didn't recall. Have you ever seen that transcript that she referred to prior to today?
No, I have not.
And you have any way of knowing if it's accurate?
Objection, Your Honor.
No.
Do you have any way of knowing if it's correct?
No.
You don't know if it's
I do
right?
not think that's correct.
Okay. Nick, you testified about Engel and McComas wanting a ride. Was it just McComas, was it just Mr. Engel, or was it both?
I recall it as being both, because they both got into my vehicle, but I remember Mr. McComas getting into the front seat. Yeah, so that's, I can't remember.
Okay, and during the time that you were in the vehicle, at any point did you hear Mr. McComas threaten Mr. Engel?
Not that I recall.
Did you see him hit Mr. Engel?
No, I did not.
You said that you asked for help from Mr. Engel because you knew him, is that right?
Yeah, I assumed that he would help me. Right?
Did he help you?
No.
Was he the one, is the defendant the one that took over driving the vehicle?
Yes. Yeah.
When he got into the driver's seat, did he refuse to drive?
No, actually just kept on going in the same direction we were going. So.
I know this should go without saying, but Mr. Hunter, when you wrote that affidavit, were you upset? Had you been traumatized by this?
I mean, I would say, yeah, that's probably why most, I can't recall some of these things, is that I was just so out of it, honestly, the next day too, when they were going through all of this, and not necessarily, guiding me, but it was, they were trying to help me get the story out, and I was trying to remember things, and it was just a lot going on, so.
Has it continued to have that effect on you?
Yeah, I actually have pretty severe anxiety, actually.
What's that?
Objection. Relevance to health.
What's that?
Objection to relevance.
Okay.
I have pretty severe anxiety, actually.
I have no further questions.
All right, I'm gonna shut that back. Next witness?
Cheyenne Bowler.
Stand in front of the judge, face the judge, please.
Were you sworn in the clerk's office?
Yes, Your Honor.
All right, that seat over there. This is being shown on YouTube. Do you have any objection to it showing you? Yeah, right there. Do you have any problems with this being viewed on YouTube?
No.
All right. You may inquire. And you can take your mask down while you're speaking so they can understand you better. Make sure you keep your voice up speaking to that. All right.
Okay.
You may inquire.
Thank you. Can you please state your name for the record?
Cheyenne Bulmer,
And can you spell your first and last name, please?
CHEYANNEBOLLNER.
And in August of 2018, were you living in Highland County?
Yes.
Taking you back to August 30th, 2018, do you recall being on US Highway 50 in Highland County?
Yes.
And do you remember about what time that was?
About 9 o'clock.
Okay, 9 o'clock in August in Highland County. Is it dark outside? Is it pitch black?
I don't really remember, but I want to say it's It's at least getting dark.
Okay. Was it still light enough for you to see?
Yes,
And were you driving a vehicle?
yes.
Do you recall what direction you were headed?
Towards Hillsborough,
From which way?
Lynchburg
From
area.
Lynchburg area? Okay.
From where?
Lynchburg area.
Do you recall where you were headed to that night?
I was going to Walmart to get baby food.
Did you have anyone with you in the car?
I had my oldest and my youngest with me.
Now, do you remember seeing something as you drove that caught your attention?
Yes, I do.
What did you see?
I was driving down State Route 50, and I seen a man laying in the road and two other men over top of him. It looked like they were like beating him up. He was yelling for help. I did slow down, but since I had my kids in the car, I just continued to drive and called him.
You called it into the sheriff's office?
I did.
Okay. I have no further questions.
Ross?
Good morning, ma'am. So when you drove by, you said one person was laying on the ground and the two other ones were standing?
Yes.
Okay. So at no point did you see someone see anyone actually make contact with the individual that was on the ground?
I actually seen them trying to see, but it's very fuzzy. But yeah, I actually remember them either trying to pull him up to get him into, throw him into the back seat, or trying to keep him from running off.
When you're saying all that, I think that was happening, I would like to focus on what you actually observed. Did you ever stop your car?
Not a complete stop, but I slowed down to maybe about 15 miles per hour.
Okay, so you were driving by. You didn't see anyone strike or how the man got on the ground, fair?
I mean, the way they were holding their arms, you could definitely tell that they were doing something to him.
Okay, when you say they, can you say specifically what you observed?
Two men standing over him, and it looked like they were hitting him as I was pulling up.
What I asked was, instead of using the word they, can you be more specific as to what you observed as to each individual that was standing?
I mean, other than what I just said, two men were standing over him, and he was laying on the ground screaming for help at the top of his lungs. I heard that with my windows up as I was driving by.
Okay. But when you're saying it looked like they were doing something, can you say what specifically each of the people was doing with their actions?
I just told you that the way they had their arms positioned, you know how it looks when someone's throwing punches, especially if they're laying on the ground. That's the position they were in.
So you're saying both individuals were punching the man on the ground? That's your testimony?
That's not what I said.
Can you please explain what each individual was doing to the person on the ground?
My answer has not changed. I mean, I don't know how else to say it. I'm telling you exactly what I seen.
So if the man on the ground testified that not both of them struck him, would that confuse you?
I'll sustain that.
Can you describe with your body, let's start with, what do the men look like that were standing?
I mean, I wasn't that close to them.
But you just said you were close enough to see exactly what was happening, so can you describe
I mean, I
each of the
had to
men?
go over to the other lane and literally pass them, so I've seen two men standing over another man and the man yelling for help, so yeah. But other than that, I did not see details.
Can you testify exactly the stance of each of the individuals for me, please?
Okay, so let's say he was here laying on the ground, one was here, and the other one was on the other side, maybe more over his head in a way, and the other one was down towards his legs on each side.
And what were they wearing?
I do not recall that.
Okay. Approximately how long did it take you to drive from when you first saw them to then when they were out of your eyesight?
Can you ask that in a different way?
How many seconds did you observe the three men on the side of the road?
I mean, maybe just 5 seconds. It was very brief. Very brief.
So in all that time, you were able to see an attempt to punch and an attempt to put in the vehicle in 5 seconds?
Well, I mean, you know how State Route 50 is. It's just one long straightaway. And yes, as I was driving up, I seen something was going on. I heard the man yelling, which was even more alarming, so I slowed down. So yeah, I could see that something was going on as I was approaching. and I slowed down and seen them as I was passing.
But you couldn't say definitively what happened to get to that point. I have no further questions.
Redirect.
Thank you. Ms. Fulmer, did you slow down as you observed the two men standing over the person on the side of the road?
Yes.
And did you slow down so as to get a good look at what was happening?
I did because I was concerned, you know, he was yelling for help, but it just didn't feel like a safe situation with my kids in the backseat.
Based on the stance of the two men over the person on the ground, did you feel the person on the ground was in danger?
Yes.
Is that what you reported when you called the sheriff's office?
Yes.
Do you typically just call the sheriff's office every time you see somebody stopped on the side of the road?
To be honest, this is the first time I've ever called anything in.
No further questions.
Okay, make that down. Make that down, Ms. Moore. Thank you. Your next witness.
J.D. Adams.
Please, Judge Wood.
Are you sworn in the clerk's office?
Yes, sir.
All right, have a seat right there. Put the mic over in front of you, please. Give any objections being shown on, YouTube?
No.
You can pull that down, that's fine, yes. May inquire.
Thank you. Can you please state your name for the record?
Sergeant J.D. Adams.
Are you currently employed?
Yes.
Where are you employed?
County Sheriff's Office.
And how long have you been employed with the Highland County Sheriff's Office?
In various capacities for 20 years.
Prior to that, where were you employed?
Indiana Police Department.
Taking you back to August 30th, 2018, were you employed at the Sheriff's Office?
Yes.
In about 9 or so, did you receive a call to respond to US 50?
Yes.
Let me back up and say 9 in the evening.
Yes.
And where did you respond to?
The area of Fairview.
And what were you looking for?
We received a call of two males outside of a vehicle with the third male laying in the ditch hollering for help.
Did
There's
you?
supposed to be a vehicle as well, I believe a Cavalier, if I recall correctly.
Did you respond to that location?
Yes.
And were you able to find the people?
No, I was unable to locate anything in that area.
No further questions.
Ross?
I have no questions.
All right, make that down. How long is your next witness, ma'am?
My longest witness, actually.
All right, so we'll go ahead and take a break then at this point. It's 11:40. So we'll break a little bit early. So we'll break for 1 hour, and we'll be back here in the courtroom at 12:40. During the break, remember the instructions of the court are not to speak to anyone about this case, and not to talk to any parties or witnesses or anyone else about the case. Not form in and express any opinions about the matter because you still haven't heard everything that's going to take place in the trial. Do not look up anything on the internet about the case or anything you've heard about. Don't post anything on the internet, social media, review any postings or articles of any sort, or listen to any broadcasts or podcasts if there are any that pertain to this matter. So when you finish, make sure when you come back and turn your phones off, you have a seat there, take your seat. I'll also tell you that when we do submit the case to you, which looks like it'll be, this afternoon, you'll have to surrender your cell phones. Usually the bail just picks them up and keeps them in a bag, gives them to you after the case is over. But if you prefer, don't bring it back in the courtroom if you don't want to take a chance on losing it. We've not lost one yet. I wish we had, maybe, but yeah. So anyway, those are the instructions of the court. So I'll be back at 12:15. Thank you.
Please rise.
Thank you, Chief. Please. All right, next witness we'll see.
Deputy Alexander.
You just sworn in, Deputy?
I have your own.
All right, just right there. Here. You know, if you do. I do not. All right, you make it, man. Yeah. Name bar.
Please state your name for the record.
Deputy Stephen Alexander.
Are you currently employed?
I am.
Where are you employed?
The Highland County Sheriff's Office.
How long have you been employed with the sheriff's office?
In various capacities since August of 2005.
So you were there, employed there on August 30th of 2018?
I was.
And what were your duties on August 30th, 2018?
I was assigned to the Road Patrol Division on that evening.
At around 9:30 that evening, did you receive a call to respond to a scene involving Dustin Hunter?
I did.
What was the nature of the call?
We had received a report that a male had been assaulted and then left on a street in Hillsborough.
And where did you respond to?
It was the area of 653 Spiegel Street.
And what did you find when you arrived there?
Found a vehicle that was unoccupied and sitting in the middle of the dead-end portion of Spiegel Street. Several Hillsborough police officers on scene and Paint Creek Fire and EMS.
Upon arriving, what did you do when you arrived there?
I spoke with the responding Hillsborough police officers and was able to begin processing the vehicle.
When you say processing the vehicle, did that start with taking pictures?
It did.
May I approach the witness?
Ma'am?
I'm going to hand you a previously been marked as State's Exhibit 3 for identification purposes. Do you recognize that?
I do.
What is that?
That is the back seat of Dustin Hunter's vehicle and containing a vomit stain.
Next, I'm going to hand you what's previously been marked as State's Exhibit 4 for identification purposes. Do you recognize that?
I do.
And what is that?
That is the rear of the passenger seat of Dustin Hunter's vehicle that has blood on it.
I'm next going to hand you what's previously been marked as State's Exhibit 5 for identification purposes. Do you recognize that?
I do.
And what is that?
That is another angle of the back seat of Dustin Hunter's vehicle with vomit.
And State's Exhibit 6. And do you recognize that?
I do.
And what is that?
That is the seat. I can't tell if it's the driver or passenger at this point. It appears to be driver. And it has blood on it as well.
And finally, State's Exhibit 7. Do you recognize that?
I do.
And what is that?
That is the bloody white t-shirt that was found directly beside the driver's side door of Dustin Hunter's vehicle.
Now, when you took pictures and looked through the car, did you take any fingerprints from the car?
Not that evening. The vehicle was towed back to the Highland County Sheriff's Office where it was processed the next day by myself and another sergeant. We were able to lift prints, however, they were not sent off to BCI as they did not contain sufficient ridge detail.
What do you mean they didn't contain sufficient ridge detail?
The ridge detail is what identifies a fingerprint. If there's many things that play into being able to lift a fingerprint.
I would object at this point if the testimony is going into the realm of expertise in fingerprints.
But did you really? You can continue.
There's several things that play into being able to lift a fingerprint, texture of surfaces, if weather has been, to it and things of that nature. Once the prints were lifted from the various places within the vehicle, there was not a print that BCI would have accepted.
So you didn't send any prints?
I did not send any prints.
Objection.
Did you respond to the Highland District Hospital to speak with Dustin Hunter?
I did.
And did you observe any injuries to Dustin?
Yes, I did.
Did you take pictures of those injuries?
I did.
May I approach the witness?
Ma'am.
Give a hand to what's previously been marked as State Exhibit 8 for identification purposes. Do you recognize that?
I do.
What is that?
That is a picture of Dustin Hunter laying in the hospital bed at Highland District Hospital.
And is that a focus of his entire body?
Yes.
Okay. I'm next going to hand you what's previously been marked as State Exhibit 9 for identification purposes. Do you recognize that?
I do.
And what is that?
That is a picture of a close-up of Dustin Hunter's face.
And State Exhibit 10, do you recognize that?
I do.
And what is that?
That is a side angle of Dustin Hunter's face from that evening.
And State Exhibit 11, do you recognize that?
I do.
And what is that?
That is a bite mark on the right chest area of Dustin Hunter.
And State Exhibit 12, do you recognize that?
I do.
And what is that?
That is an abrasion on Dustin Hunter's left shoulder.
State Exhibit 13, do you recognize that?
I do.
And what is that?
That is a close-up of the abrasion on Dustin Hunter's left shoulder.
State Exhibit 14, do you recognize that?
I do.
And what is that?
That is a picture of the scrapes and abrasions on Dustin Hunter's back.
State Exhibit 15,
That is a picture of scrapes on Dustin Hunter's right hand.
and 16,
That is a picture of Dustin Hunter's right arm, and it shows an abrasion in the elbow area.
and 17.
That is a close-up version of the same picture, or the same arm.
Now, was Dustin able to recall what happened to him?
Dustin did give an account of the events of that evening, yes.
Was he able to identify the people that were involved with this?
Yes, he was.
And who did he identify?
He identified,
He's already testified.
Overruled.
She was asking about the night of, Your Honor.
Well, he's testifying. So,
And who did he say?
it was Brandon McComas and Brandon Abel.
And did you meet with Dustin again at a later date?
I did.
And what was the purpose of that?
To basically nail down details from the evening prior.
Now, was one of the purposes to try to figure out the route that was traveled?
Yes, it was.
And based on Dustin's statements as well as Ms. Bulmer's statements when she called in, were you able to put together a route that was traveled that day?
Yes, we were.
I'm going to show you what's previously been marked as State Exhibit 18.
Your Honor, may we approach?
No.
I'm gonna show you, here was previously been marked as States Exhibit 18.
Your Honor, I would object to it being published to the jury if it's not being exhibited in the record.
Your Honor, he's going to look at this and point out the areas on here that he has knowledge of. Okay. Thank you. Deputy Alexander.
Yes.
Based on the different descriptions that Cheyenne gave you as well as Mr. Hunter gave you, and where the car was down, were you able to map a route that was taken?
Yes.
Okay, and can you tell us where in Highlands County you were able to first determine they were?
I was first able to determine that Dustin had traveled through, Dustin, the defendant, and Mr. McComas had traveled through Buford. He distinctly remembered passing the gas station in Buford on Greenbush West, which turns into State Route 138. They then travel up 138 towards Hillsborough. He gave an approximate time. I believe it was 15 minutes, is what he stated.
Objection, your side.
Just saying that.
Based on what he told you, what's the next road?
He was unable to recall the name of the road, but he recalled making a left-hand turn. Then he described a church that we know it sits on Danville Road just south of Roushrood. This is where he states that the first.
Okay.
He testified to this.
Your Honor,
You may go. All right, may I continue?
Do you recall Mr. Hunter describing State Route 50 in the courtroom, being traveling on State Route 50?
I do not recall him specifically stating that he was on US Route 50.
When Cheyenne Bulmer called in, what road was she on?
She was on,
She testified to
That's
it.
overruled.
The question was when she called in.
When she testified today and said where she called about, what road did she say?
she stated she was on US Route 50.
From there, where were you called to find Mr. Hunter?
I was called to the area of 653 Spiegel Street, Hillsborough.
Okay, were there landmarks in Hillsborough, Mr. Hunter testified to today, that you know of in town?
Yes.
What were those landmarks?
He specifically listed Treewood Apartments, the sign at Taco Bell, the Wendy's sign. He specifically stated that he believed he was headed out of town as there was a lack of street lights, made another turn, and then that's when the vehicle came to rest.
Now, do you have knowledge of, other than of where Spiegel Street is?
Yes.
Okay, can you just describe where that is?
Spiegel Street, if you're leaving from this courtroom, you go down to Northeast Street, make a left, take it down past Samaritan Outreach, where the pet grooming place is there at the bottom of the hill. Once you get to that hard right curve, that's where Northeast Street ends, that's where Spiegel Street begins. There's a dead-end portion that heads up to the left, and then the rest of it continues out to Greenfield Pike State Route 138.
And where is Mr. Hunter's car located when you were called to the scene?
On the dead-end portion of Spiegel Street.
Okay. So, the area of Fairview that Ms. Bulmer testified to today on US 50 and Spiegel Street, those various areas, are those in Highland County?
Yes, they are.
And our state's exhibits 3 through 17, those would be all the pictures that you identified. Are those true and accurate depictions of the scene as they appeared that day?
Yes, they are.
I have no further questions.
Awesome.
Thank you. Officer, the prosecutor asked you some questions about Cheyenne Bulmer. Actually, I'm going to come back to that. Were you the lead officer on this case?
I was.
Okay. So is it part of your responsibilities to review all of the incident reports?
Yeah.
Well, the incident report has several pages. Is that you adding supplements to it as your investigation develops?
Yes.
Okay. And is it important for those incident reports to be accurate?
Yes.
Okay, I know that sounds obvious, but so here we are 4 years later, sometimes cases, drag on. So is it important that you put information in those reports that's accurate?
Yes.
Okay. And so on the report for Cheyenne Bulmer, the fact that the report says she only saw 2 males, how do you explain that?
Stay that.
How would that affect your investigation?
Unless the state has to have established that that's what it says. You can't testify.
Your Honor, may I approach?
Right.
Could you take a look at that, please? And on the top, I think you put case identifying information. Is that on there?
Case identity. I'm not sure what you're referencing.
I'll approach with another one. Does it have, sorry. Does it have the same case number on each of these reports?
Whose
It does.
report is this? Is it his report?
There's two different officers.
We need to ask him about his report.
Well, as the lead officer, do you review the reports in this case?
I,
I'm gonna object to whatever somebody else's report says, whether we repeat it or
We're
not.
sustained that objection.
Sir, in your job duties, if you receive conflicting information, is it your job to investigate that?
yes,
So if one witness said there were 3 people and one witness said there was 2, that would be important for you to hash out what's the correct answer.
yes,
Okay. And you heard in court Cheyenne say there were 3 people that she observed.
yes,
Okay. So if there was another statement that was different, that would affect the course of your investigation.
yes.
And whether or not that witness was able to actually view what she testified to viewing, or said she viewed.
Ma'am, I'm unable to answer this as that Sergeant, or now Sergeant Adams, it was Deputy Adams' report. I did not speak with Cheyenne Palmer, I was not given the initial call.
Okay, but let's say you are the lead detective on the case, fair?
I'm not a detective.
You're the lead officer on this investigation that led to this arrest.
Yes, ma'am.
Right, this has been asked and answered.
We'll sustain the objection, move on.
Did you interview Cheyenne Palmer yourself?
I did not.
Okay. And at any point, you didn't interview Mr. Engel at all, did you?
Your Honor, objection.
Basis?
Let's approve.
Sir, now when you approached, the vehicle was in the middle of the street, is that correct?
Correct.
Okay, so it wasn't parked in a lawful parking space.
Correct.
And you testified that you interviewed Dustin before signing a warrant for these charges, correct?
Yes.
Okay. And anywhere in your investigation notes, your summaries, did you put in there that Brandon Engel told Brandon McComas to stop? Did you put that anywhere in your reports?
Not that I recall.
Okay. Even though you learned that from a witness through the course of your investigation? You didn't think that was important to include?
If I recall correctly, the initial statement made no mention of Mr. Engel telling Mr. McComas to stop. The second interview Mr. Hunter does make reference to making comments to Brandon Engel. I don't recall the specific comments.
If I handed you a transcript of that interview, would that refresh your recollection?
Your Honor, objection. Which interview? He's talking about the first and the
Well,
second.
the interview, you can't cross-examine him on that witness's interview. You use that to cross-examine that witness, so that door is closed. Move on. Sustain.
Your Honor, can we approach about something?
I mean,
Can we approach about something?
Objection, well, I was objecting, you may proceed. If there was an objection, so we'll vote it out now. And you may proceed.
Sir, do you remember writing out a search warrant for Brandon McComas' DNA?
Yes.
Objection, relevance?
Okay,
If I can ask the next question, I think the relevance will be established.
the Colis's DNA?
Correct. He's
That's
charged
the
as
same.
a co-compulsor.
Pardon?
What he did in this investigation relating to client, which is the next question I was gonna ask, is relevant.
Well, then ask the question about your client.
You did not write out a search warrant for Brandon Engel's DNA, correct?
Correct.
You did not conduct an interview with Brandon Engel before signing charges, correct?
Correct.
I have no further questions.
Were you right?
Deputy Alexander, Mr. North commented on Cheyenne Bulmer giving different statements. In your duty to investigate that, have you heard of different statements? Or give different statements?
No.
Had you heard that, would you have investigated that?
Your Honor, I'm gonna object because the objection was sustained when I started asking about Ms. Bulmer's.
Yeah, I sustained that, because there's no evidence of that, so
Unless
she
I
could
make
have
this
heard,
question,
she made the comment in her question, and her question is not evidence, so I sustained that objection. I sustained that.
Why didn't you write a search warrant for the defendant's DNA?
Based on what Dustin Hunter said, I didn't believe that Mr. Engel's DNA was relevant. I didn't need it.
Well, why is that?
The physical portion of this was done by Mr. McComas, according to Mr. Hunter.
Did you have any question that Mr. Engel was in the vehicle?
No.
Did you have any doubt that he was driving the car?
No.
No further questions.
All right, Ms. Stephanie. Next witness.
No further witnesses.
All right, Councilman Brooks. All right, state resident. Oh, I'm sorry, Councilman Brooks. All right, state is rested. Now, that's case. First witness, you're up.
Your Honor, we would like to call Brandon Engel.
Right.
Go ahead and stand.
Raise your right hand before. You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Let's see right there.
Brandon, I'm gonna ask you a few questions, just keep your voice up, we've heard that for the last few witnesses, just to make sure they can hear you, okay? Will you please state your name and spell your last name?
Brandon Engle, E-N-G-L-E.
Brandon, where do you currently live?
I live at 512 Brookwood, Alexander, Kentucky, 41001.
Okay. And back in August of 2018, where were you living at that time?
I was living at my mom and dad's house, 3951 Virginia Street, apartment 308, Cincinnati, Ohio.
And are you working right now?
Yes, at Inscapes.
Okay. What do you do for them?
So I do patio pavers, retaining walls, I do landscaping.
Okay. Do you have any children?
Yes, I have 2 stepchildren and I have 1-year-old son.
Okay. Now I'm gonna ask you some questions that may make you uncomfortable, but do you have a criminal record?
Yes.
Okay. Can you, Your Honor, I'm not impeaching, it's an open-ended question.
Okay, you are impeaching, that's an impeachment question, so, can't impeach your own witness, that is sustained.
Okay. Where did you grow up?
I grew up in Batavia, Ohio.
And growing up, did you know someone named Dustin Hunter?
Yes, ma'am.
Okay. How do you know Dustin?
Through school, and I used to live in the same trailer park that he used to live in.
And did you remain friends after school?
Yes.
How often would you see him?
Not too often, but I mean, we were still, good friends, but not like best friends.
Okay. And have you ever had any issues with Dustin? Any
No.
fighting or anything like that?
No, never.
And do you know a person named Brandon McComas?
Yes.
Did you know that person in August of 2018?
Brandon McComas, yes.
Yes. Sorry, I should have specified. So I want to talk about the day before. Okay. That would have been August 29, 2018.
Okay.
Can you tell the jury what you remember about that day?
So that day, I called Dustin Hunter and asked him for a ride, and he said he
Where?
From my dad's to Brandon McComas' house.
Okay.
And I gave him $25. And then, so we went to Brandon McComas' house, and then we went to IHOP.
Okay, so I'm going to stop you. Did you pay him when you got in the vehicle or after?
I paid him when I got in.
Okay. And after you got to Brandon McComas', did all 3 of you go to IHOP?
Correct.
Okay. And did you purchase anything for Dustin at that restaurant?
Yes, I bought him dinner.
Do you remember why?
Just because he's a good friend. I mean, I've never had no problem.
Yeah, Jack, this is wholly irrelevant.
It's involved all the parties.
I mean, I'm gonna overrule it, what they care.
Now, the next day, did anything else of note happen that evening?
No.
Okay. Now let's talk about the next day, August 30th. Did you happen to communicate with Dustin?
Correct.
Can you explain that,
So
please?
he called me, he was asking about his stuff, like a missing bag, whatever, with battery, drum batteries in it. And so when I was at Brandon's, after he called me, and then I called him back, and I said, yeah, Brandon McComas took your bag. Well, Brandon McComas said that he...
Objection.
Without saying... Sure. So without saying what Brandon McComas told you, at some point with the bag, was the bag the reason for the call? You guys were communicating about Dustin's bag?
Correct, Dustin called me and asked me.
Okay, and then at some point did you see Dustin that day?
Correct.
Can you tell me about where?
So he came and got his bag at, it was like, I don't know, probably like 7:30. He came and got his bag, and then I took it down to his car, gave it back to him, and then Brandon comes right behind me, and he asked, Brandon comes and asked Dustin Hunter.
Objection.
Didn't get a lot.
Brandon, without saying what he said, try to just describe like the events as they happened, not what people were saying. I know that's confusing, but just describe what happened, okay? So, I'll back up. Did you give Dustin his backpack?
Yes, ma'am.
Okay. And then at some point, was there discussions about a ride?
Correct.
Okay. Do you remember who initiated that conversation?
Brandon McComas.
Okay. And do you remember, what was your plan for the evening?
So we were going to go drink at his brother's house, Brandon McComas' brother's house. And Dustin really didn't want to give a ride, but he gave in. I told him I'd give him $40.
Now, to back up, was it his brother's house or his sister's house?
No, he told me his brother's house.
Okay, so you're planning on going to the brother's house,
Correct.
and then, did you give Dustin any money?
Yes, I gave him $40.
Okay. And then did he drive you from Brandon McComas' house?
Correct, to the church.
Okay. So let's start with, when you got in the car, what did you believe the purpose of the transportation was for?
Then we were going to go hang out with Brandon McComas' brothers.
Okay. Did you have any plan to rob Dustin when you got in that vehicle?
Absolutely not.
Okay. Were you aware of any plan by anyone to rob
Absolutely
Dustin?
not.
Now talk about that ride. Tell the jury what happened.
So on the way there, we were going and was listening to music. I mean, we weren't really talking that much. I mean, me and Dustin were talking back and forth. Brandon was in the back seat. And then as soon as we pull up to the church, that's when Brandon said we're gonna walk the rest of the way. So, I mean, I really didn't understand that, but so we started walking, and then I got out of the car.
So I'm gonna stop you. Did the car actually come to a complete stop?
Correct.
Okay, and was that still on the road or was that in a church parking lot?
So it was still on the road, but Dustin I guess he was trying to back out, or like back into the church, that way he could turn.
Okay.
And then that's when I was like, I don't know, I was probably like 25, 50 feet away from the car.
So I'm gonna stop you. When you're saying he's still moving the car, you were out of the vehicle?
Correct, so I got out of the vehicle on the street, and then I started walking like up by the gravel driveway of the church. And that's when he said he wanted to talk to Dustin. I said, okay, Brandon McComas.
Objection, what
So-
Brandon McComas said.
Your Honor, it's not going for the truth of the matter, so there's gonna be effect on that.
Oh,
So, just to be clear, you got out of the car, was Brandon still in the car?
Correct.
Okay, and what happened next?
So then,
That you observed?
what I observed was Brandon McComas wrapped the seatbelt around his neck. Then, not at that yet point, did he reach over and bite him. But I contemplated in my head just to get away from the whole situation. I was just going to run, because I didn't want to be no part of it. So then, as soon as he wrapped the seatbelt around his neck, he's screaming, Brandon, like
Who's he?
Dustin Hunter.
Okay,
And he was screaming for my help.
so then what did you do?
So then I went back to the car, and then that's when Brandon McComas bit Dustin. And then that's when they started fighting and tussling. And then that's when they got out of the car and they started fighting each other. And then Dustin got back in the car, and then I got back in the car because Brandon told me to get back in the car. And at this point, I was intimidated and scared by Brandon McComas.
How would you describe Brandon McComas' demeanor at that point?
He was very aggressive, like I've never seen him act like that ever.
Okay. Did it scare you?
Absolutely.
So, now everyone's back in the car, what happened next?
So then Brandon is in the back seat, I'm sitting in the passenger seat, Dustin is driving.
Okay.
So,
Was there still like conflict going on between the two of them or had that ceased?
no, it kind of ceased.
Okay. So then what happened?
So then Dustin started driving again, then I don't know how far, maybe like, 5-10 minutes, probably maybe that long, probably 5-7 minutes. Dustin stopped. I don't know if it was at a stoplight or if it was at a stop sign, but he stopped. And when he stopped, he pulled his car like just a little bit off the road. That's when he jumped out. And then that's when Brandon told me, he's like, get in the fuck.
Objection.
Runner, it goes to his state of mind as he was acting. I'm not offering it for the truth. Go ahead.
So as soon as Dustin jumped out, Brandon jumped out to get Dustin. And then that's when Brandon said, get in the fucking driver's seat and drive. So at that point in time, I was so intimidated and scared by him, I didn't know what to do. So then Brandon Cummings put Dustin in the back seat, told him to keep his hands up on the seat. And he was navigating me, but I had no idea where I was going.
Are you from here?
No, absolutely not.
Have you ever lived in Hillsborough?
No.
Was it light or dark out when you were driving?
It was dark. Pitch black.
Can you just explain why you were driving?
Because I was scared, honestly. I was afraid of Brandon Cummings. After what I just seen him do to my friend, I was honestly scared.
Why didn't you run?
Because if I would have ran, he would have ran after me.
Did you see him run after Dustin at the point where Dustin had tried to run?
Right, yeah.
Okay. And at that point in time, were you trying to help Brandon McComas with whatever he was doing?
Absolutely not. And the first time I went back to the car when we was at church, I told him, I said, chill the fuck out, leave him alone. And he wouldn't.
Do you know how many times you said that to him?
At least 3 times. And then he was like, what, you want some too? Like, telling me like.
Objection.
Did his behavior start quickly? Like, can you explain that? How that, or did it evolve? Have you been angry the whole car ride?
No, it was just like, it was like a light switch. He just, like as soon as I got out of the car, he just started acting crazy.
Okay.
I've never seen Brandon McComas act like that, ever. And I've known him for like 5 years prior to that event.
Okay. And why did you eventually stop the car?
Because initially I wanted to get to a place where there was more buildings and more places around. And then I saw apartments, and I just stopped the car and I pulled into this house with a gravel driveway. And then, so as soon as we got out, Dustin was in the back seat. And Brandon McComas is like, well, I'm going to take his phone. And I said, no, don't do that. They're going to track you. But I knew in my head that was the way for Dustin to get help.
What, leaving the phone with him?
Correct.
Okay. At any point, did you put your hands on Dustin?
Absolutely not.
Did you ever indicate, even if it was subtly, to Brandon McComas that you were condoning what he was doing?
Absolutely not.
Did you take any of Dustin Hunter's belongings?
No, ma'am.
Did you ever get any of his belongings, even from what Brandon took?
Absolutely not.
How big is Brandon?
Maybe, I don't know, he's probably like, he's probably like 4 or 5 inches taller than me, a little more stocky than me.
Okay. What were you feeling when you were told to get into the driver's seat?
Like, anxiety overtook, I started freaking out, and I didn't know what to do. It was just acting on instinct, and I was scared.
When you were driving, at any point do you remember Brandon McComas mentioning a gun?
I didn't hear nothing about a gun.
Okay. When you were driving, was Brandon McComas still assaulting Dustin, or had that stopped?
No, it stopped. He told him just to keep his hands on the seat. It's not like he was in the back seat to beat him. It wasn't like that. The more of the fighting happened outside of the car.
Did you stop at the first location you thought it was safe?
Yes. Because I was just trying to get out of the situation, and I wanted Dustin to get help.
How long did all this last? Was it quick? Was it long?
I'd say maximum 15 minutes.
Okay. Did you want to get out of the car?
Absolutely.
What did you do after you got out of the vehicle?
So when I got out of the vehicle, Brandon McComas was telling me, he said, come on. At that point, I was intimidated, scared. I was like, all right. So I just walked away from the car. I knew that Dustin had his phone in order to call for help. Then we walked from where the car was at to the apartments. And then there was some guy there, and he was talking to some girl outside.
Who's he?
I have no idea who
Okay.
it was. So he was talking, this guy and this girl were talking outside the apartment. He had a black Ford Focus. And Brandon asked him if we could get a ride to his sister's house, but I thought we was going to his brother's house. But anyway, we went to like 3 blocks away from the sister where this dude dropped us off at, and we walked the rest of the way to his sister's. And then when I got to his sister's, he went in the back bed, so his sister has a 2-bedroom apartment, and he went to the back bedroom, and I sat on the couch and stayed awake all night long until his sister took me home the next morning.
Did you tell anyone about what had happened?
Yes, I told my mom and my dad. So when Brandon and his sister dropped me off at my parents' house, I told my parents what happened. So then Brandon McComas comes back to my parents an hour later, he's wanting to fight me, this and that. Like, my mom was like,
Objection.
I was staying there.
Your Honor, I think it does go to his mental state about.
No, this is the next day, it's not there. It's staying.
You hadn't gone to sleep yet, correct?
correct.
Okay. And did you ever see Brandon McComas again?
No, that was the last time ever.
Why?
Because I couldn't believe what he did, and I don't want to be around somebody like that. It was the last time I ever talked to him, too.
At any point that evening, did you want any part of what was happening to Dustin?
Absolutely not.
Thank you, Brandon. I have no further questions.
Hey, Ross.
I have just a few questions. Start, Mr. Engel and Annika Collins, I'm Ohio County Prosecutor. Let's start with your prior criminal history. Have you previously been convicted of a felony in the past 10 years?
Yes, ma'am.
And what felonies?
So I have a burglary, and I have 2 breaking and enterings.
All
And 2
felonies?
Yes, just 3 felonies.
Okay. And are you currently still under the sentence of those cases?
I would object, Your Honor, to relevance because it's not just like.
Now, you testified just a moment ago that Mr. McComas is, did you say 5 to 6 inches taller than you?
I think it's something like that, yeah, about 4 or 5, something like that, yeah.
Okay, and that's your sworn testimony?
Yeah, absolutely.
Okay. Now, today, you expect this jury to believe that you were so afraid for your life that's why you drove.
Absolutely.
Okay. But, and on August 31st, you were still afraid, is what you testified to a minute ago.
Yeah, I was still afraid of him, absolutely.
Did you call and check on Dustin afterwards if you were so concerned about him?
No, I didn't, because I didn't want to.
Did you call law
Your Honor, I think he hasn't finished his answer. I want the witness to finish his answer.
The reason why I
Wait,
didn't call.
wait, I can't hear your objection.
He was still finishing his answer before the prosecutor asked him.
The question was, did he call to check on him? The answer was no. So, move on.
Did you call law enforcement the next day to explain what happened? Yes or no?
No.
Your Honor, he doesn't have to answer yes or no. That's not found by the rules. If he has an explanation,
Oh,
he's
I
permitted to
disagree.
give that.
I disagree.
Mr. Engel, are you familiar with an area, 1391 Sutton Avenue in Anderson Township?
Yes, ma'am.
Okay, and isn't it true that you and McComas were staying in an apartment there?
That's absolutely false.
Do you know what area I'm talking about?
You're talking about his grandma's house, and I did not stay there. I stayed there a couple of days here and there on a weekend.
Okay. So, isn't it true you were there on September 1st, 2018?
No, that's absolutely false.
Okay. And you testified that you told McComas not to take the phone because the police could track him with that phone?
Correct, and the reason why.
And,
Your Honor, she keeps interrupting the witness as he's trying to answer a question.
The question is, did he tell him that? The answer is no.
the answer was yes, he did tell
Or
me
yes,
that.
the answer is yes.
Okay.
That way you can get.
You can read it right.
I'm sorry, it is a yes or no question. And Mr. Engel, isn't it true that from the area in Fairview, you drove from there to Spiegel Street where Mr. Hunter was left? Yes or no? Were you the driver?
I'm not familiar with the area, so I couldn't tell you, but I was after the second stop, yes.
Okay, so fair enough, that would be the Fairview stop.
Yeah, I was made to drive.
Somebody was holding a gun to your head?
No, but he was was he gonna wrap a seatbelt around my neck and bite me too?
Well, did he threaten physical harm to you?
Yeah, he said you want some too, or what, I mean, what more could it be, like?
Did you,
Beat up my friend, like, I thought he was my friend,
did you hear Mr. Hunter's testimony that he didn't hear any of that?
because he was unconscious.
Once you left the car, on Spiegel Street with Mr. Hunter laying in the back seat, did you send a text or call law enforcement? Yes or no?
No, because Brandon comes, I was scared of him.
I have no further questions.
Redirect.
Yes. Brandon, was Brandon McComas able to inflict serious damage without the use of a weapon?
Absolutely.
No, ruling.
Were you afraid of Brandon McComas on August 30th, 2018?
Absolutely.
Why didn't you call Justin the next day when the prosecutor asked you about that?
To be honest with you, because the next day they made a post on Facebook, him and his mom to attempted murders and all this and that. Like, I didn't know what to, I mean, I was going to reach out to somebody that, but he always says they. It wasn't they, it was Brandon McComas, it wasn't Brandon Hinkle.
Why did you tell Brandon McComas about the phone, about Dustin's phone?
The reason why
Not
I
to
told
take
him,
it.
because at first I told him, I said, don't take it because you're going to get to the door and track him. But I knew in my head that was a way for him to get a hold of 911 and call the police and get help.
Were you ever interviewed by the police before you were arrested?
No, ma'am.
And now, the prosecutor was asking you some questions on cross. That's, this is 4 years since this incident, is that fair? Okay. In the moment, were things happening quickly?
Absolutely.
Why did you do what you did that night?
Objection, this is outside of the scope of my cross.
Your Honor, she asked the question if you want this jury to believe you were afraid, and I think it's absolutely valid to ask him why he did what he did.
I'll allow that question no more.
Why did you do what you did that night?
Because I was worried about Dustin, I was worried about myself, and I would just acting on instinct, and I didn't know what to do, and I was scared.
Thank you.
All right. Any further witnesses?
That's it.
All right. Any rebuttal?
Yes, the state calls Deputy Alexander.
All right. Deputy, you're still on the road. You think we'll stand up?
Thank you. Deputy Alexander, are you familiar with Brandon McComas? And when I say familiar, I mean you've sat down or put eyes on him, you know him?
Yes, I've dealt with Brandon McComas many times during my tour as a corrections officer.
Are you also familiar with Brandon Ingle? As in put eyes on him, seen him?
I see him today, yes.
Okay. And are you familiar with the size of Brandon McComas?
I am.
And compared to Mr. Ingle, what is the size?
Mr. McComas is slightly taller than Mr. Ingle. Body size is very similar.
When you say, I'm sorry.
With Mr. Ingle being shorter, he has more of a stockier build. Mr. McComas is more slender.
When you say slightly taller, less than 4 inches?
Yes, absolutely, less than 4 inches.
No further questions.
Cross.
Sir, you've never seen him before today, correct?
I've seen him one time in the jail when I took an extra shift, never spoke with him, and honestly, at the time, had no idea who he was.
Okay. Do you know how to describe his exact build and physique on August 30th, 2018?
No, I don't.
Okay. Would you agree that I'm pretty slender. If I wrapped a seatbelt around someone's neck, it doesn't matter how large I am.
I don't believe size plays into that.
What if I bit you from behind? Does it matter if I'm 5'10" or 5'2"? Would you agree that I can still inflict harm?
Objection. Listen, again,
I'm done, Your Honor.
All right, staying. Do you reckon?
on one question. Do people typically shrink 3 to 4 inches from August to, or I'm sorry, even in a span of 3 years?
Not to my knowledge.
Thank you.
All right, Commissioner, any other?
No, Your Honor.
All right, ladies and gentlemen, we're going to take a recess. I'm going to have to ask you to go outside the courtroom. I think it stops rain. Stay in the building or go outside. We need to take care of some legal question. And so it's now 1:40. So come back up to the second floor and wait until we open the door. 2 around 2 o'clock. So that's give us time.
Please rise.
findings, I have findings after each count. What I'm going to do is I'm going to delete that on page 8 as count 1, and then after count 2, I'm going to move the findings and include it as both counts instead of one for each count. After I'm instructing them on complicity, I think that's where it needs to be instead of instructing on complicity after the findings. That I think is a little confusing. So it'll be moved to the end right before the break.
No objection.
All right, now, any requests or instructions from the state?
No.
All right. Ms. Deardorff on behalf of the defendant.
Yes, Your Honor. We were going to ask the court to move to adopt OJI CR 421.15, which is the affirmative defense of duress. I do believe that it's entitled to go to the jury, and they will be determining fact finder whether or not that does rise to the level. But we did put on the defendant, explain that he was in fear of great bodily harm, we detailed the whole incident and why he felt that way. Not to mention, I believe the state is going to be arguing great bodily harm was met on an element as to the victim, which is exactly what we observed and the reason for his testimony. So I definitely think that at the very least, the instruction should include that, and then it'll be up to the course of counsel to argue whether or not that's appropriate. And then to the jury for them.
I don't believe that the evidence is sufficient at this point to prove or to submit that to the jury, a defense of duress or a defense of duress. I haven't had an opportunity to look at this, but for some reason I was thinking that duress of harm to someone else is not a defense in that.
Not a defense in aggravated murder. There's a case law on that, but it's a defense to another thing. But I think that's the cross case.
And I would just add, Your Honor, that instructional rights in both states, the defendant claims the defense of duress, that he or she acted out of fear of his or her life or of great bodily harm. When a person is forced to participate in an
I have the instruction counsel ready to read it.
I'm sorry.
I'm very familiar with it.
Okay.
I will just say this. I don't think that the defendant's carried that burden of by preponderance, but that is me weighing the evidence. And I'm still pondering that. I'm going to have to take a back a look because I'm going to go back and check on that what Mrs. Collins brought up about calling another person harm, because I did have cross cases raised in the context of aggravated murder. And in the context of a claim of ineffective assistance of counsel. Here it is. No, actually, that was one where the guy claimed it was because he escaped from jail. Foreman case was decided in 2020. That was on an aggravated murder case.
Judge, I just want the record to be clear that I think the preponderance of evidence is the standard that the jury must find, not whether or not it's
I agree.
included in the.
I just said that. I said that I don't think that he carried that. That's me weighing the evidence. I don't do that. That's the jury.
Okay.
But I still have to decide whether or not it is, you can raise it in as a defense to harming another person. Would you have to have the case law on that?
Well, I brought the OJI instructions, which.
Well, I have instructions. I said case law.
On, like, specifically being admitted in kidnapping, or?
I mean, whether or not as a matter of public policy, that is an acceptable defense to harm and cause another person. I need to look at this. There is the Sapienza case, that's a 1911 case. I have it on my computer, so I'll take a break and go back on that. Now, any other question, any other requests or instructions or objections, any other instructions?
Not.
Just here on.
Well, just so the record is clear, I would object to the simplicity being added by the state of Ohio for the same reason they're objecting to our inspection. They're arguing he was complicit, we are arguing he's actually under duress, so I do think that it's, I'd like to just have that objection on the record.
Well, the evidence suggests that he was accomplice, so, and the statute provides that, we stated either as a implicit or determined offense. That would be a rule. All right, I'm gonna go make these changes, take a look. Unless I find some case law that says that we can't use it, I'm gonna allow it. I think it's pretty weak, but I'll allow it.
Please rise.
Okay, you want me to go over research at the same time? How long do you plan to?
Pardon me?
I was gonna go over research also, how long do you plan to be?
Well, I'm gonna be working on making these changes, so 10 minutes, so if you find anything, so, the jury will come back in and actually, and I'll go back and then, back in. The count is gonna be a little bit longer since we waited, so it's gonna be probably 4 hours.
You don't look good.
Where do you want the piece of evidence? Where's your other pieces of evidence?
She's got some on the desk, and then there's one's up there, the rest of them.
Put this one over here, then.
It was admitted, we just put it here, get in front of it. Yeah. Do you know whether she's going to refer to anything on this? Yeah, closing? Okay.
Oh, we've already used this in closing.
Okay. Roll.
Please rise. Thank you, please. All right, back on record. State presenting, well, I want to apologize to the folks out. I told you 2 o'clock, and I thought it would take very long, but one of the things I have to do is prepare jury instructions to give to you. And I always have those ready, usually the day or even last week. I had these drafted last week. But jury instructions are somewhat of a fluid thing in that they vary according to what the evidence is and what the ruling of legal issues was. And so oftentimes that requires a number of revisions, and that's what happened while we were waiting. We were looking at that. I had to give the opportunity for the attorneys to weigh in on it and review that and make a decision what's going to be instructed. And for the record, I did meet with counsel in chambers, and they have copies of the updated instructions, and my understanding there's no objection. Beyond that, it's already been put on record. Is that correct, Ms. Collins?
Yes, Your Honor.
And Ms. Steerville?
Yes, Judge.
Okay. All right. Ladies and gentlemen, you heard the evidence, and it's now the duty of the court to instruct you on matters of law. Now, the court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. Now, ladies and gentlemen, it's your sworn duty to accept these instructions and apply the laws as given to you. You're not permitted to change the law or apply your own conception of what you think the law should be. All criminal cases begin with the filing of an indictment. The indictment informs the defendant that he or she has been charged with an offense. The fact that it was filed may not be considered for any other purpose. A plea of not guilty is a denial of the charge that puts in all essential elements, puts in issue all the essential elements of the offense, or in this case, offenses. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense that has been charged in the indictment. Again, two in this case. Now, reasonable doubt is present when, after you have carefully considered and compared all of the evidence, you cannot say that you are firmly convinced of the truth of the charge. It's a doubt based upon reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Well, ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witness. You will apply the test of truthfulness that you apply in your daily lives. These tests include the appearance of each witness upon the stand and their manner of testifying, the reasonableness of their testimony, the opportunity they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness, their lack of it, their intelligence, their interest and bias, if any, together with all of the facts and circumstances surrounding the testimony. Applying these tests, you'll assign to the testimony of each witness such weight as you deem proper. The testimony of the defendant is to be weighed by the same rules that apply to other witnesses. Now, you're not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony. You will determine what testimony is worthy of belief and what testimony is not worthy of belief. Now, each witness was subject to direct examination by the party who called them and cross-examination by the opposite party. Now, during cross-examination, counsel was able to inquire into matters that did not directly relate to issues before the court. Such questions and answers were permitted for the purpose of helping you determine the credibility and weight to be given to the testimony for another purpose. There was also testimony listed as to the prior convictions of the defendant. Those would be considered only for the purpose of determining his credibility and for no other purpose. Now, ladies and gentlemen, evidence is all of the evidence that was testimony that was received from the witnesses, and any exhibits that the court has admitted into evidence during the trial. Evidence may be either direct or may be circumstantial or may be both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which they testify. And it includes, of course, exhibits admitted into evidence during the trial. Circumstantial evidence is proof of facts or circumstances by direct evidence, from which you may reasonably infer other related or connected facts, which naturally and logically follow according to the common experience of mankind. To infer, to make an inference, is to reach a reasonable conclusion or deduction of facts which you may but are not required to make from the other facts which you have found to have been established by direct evidence. Whether an inference is made rests entirely with you. When considering circumstantial evidence, you may not draw one inference from another inference, but you may draw more than one inference from the same facts or circumstances. In other words, you cannot stack one inference upon another inference to reach a factual conclusion. Now, if the circumstances create inferences that are consistent with either acquittal or guilt, the defendant must be acquitted unless the inferences in favor of guilt rise to the level of proof beyond a reasonable doubt. In the absence of direct evidence of the person's guilt, circumstantial evidence by itself may justify finding him guilty. If the circumstances are entirely consistent with the defendant's guilt and wholly inconsistent with any reasonable theory that he's not guilty, and are so convincing as to exclude a reasonable doubt of guilt. Where the evidence is both direct and circumstantial, you must decide whether the combination of the two types of evidence overcomes the presumption of innocence and convinces you beyond reasonable doubt the defendant is guilty. Evidence does not include the indictment, the opening statements, or closing arguments of counsel. Opening statements, closing arguments, as the court has indicated previously, are designed to assist you. They are not evidence. Any statements that may have been stricken by the court that you were told to disregard are not evidence must be treated as though you never heard them. You must not speculate why the court sustained any objection to any question or what the answer to that question may have been. You may not draw any inference or speculate on the truth of any suggestion that might be included in a question that was not answered. Now, the law under which the defendant is charged in count 1 is entitled kidnapping. It is numbered Ohio Revised Code 2905.01b2 and states in pertinent part as follows: no person, by force, stealth, or deception, or in the case of a victim under the age of 13 or mentally incompetent, by any means, shall knowingly do any of the following under circumstances to create a substantial risk of serious physical harm to the victim, or in the case of a minor victim under circumstances needed to create a substantial risk of serious physical harm to the victim, or cause physical harm to the victim. Number 2 of that is restrain another of a person's liberty, which is the only thing that applies in this case. The defendant is charged with kidnapping under that section. Before you can find the defendant guilty, you must find beyond reasonable doubt on or about August 30, 2018 in Hyden County, Ohio. The defendant did by force, threat, or deception, knowingly, under circumstances creating a substantial risk of serious physical harm to Dustin Hunter, restrain the liberty of Dustin Hunter. The elements of the offense of kidnapping are as follows: that the defendant did 1, by force, threat, or deception; 2, knowingly under circumstances creating a substantial risk of serious physical harm to Dustin Hunter; 3, restrain the liberty of Dustin Hunter; and 4, the offense occurred in Hyden County on or about the date alleged indictment. Now, it is not necessary the state prove the offense was committed on the exact date as charged in the indictment, sufficient to prove that it took place on a date reasonably near the date claimed. Before you can decide whether the state has proved beyond reasonable doubt all the essential elements of the offenses with which the defendant is charged, you must first decide whether this is the correct county in which this trial should be held. The defendant must prove beyond a reasonable doubt that all or any part of the offense was committed in Hyden County on or about the date alleged. Now, of course, it means any violence, compulsion, or constraint physically exerted by any means upon or against a person or thing. I have trouble on both. I told this in the threat means any statement or conduct, whether direct or indirect, exerting pressure sufficient to overcome the will of another, or make another fearful or apprehensive of injury or harm. Deception means knowingly deceiving another or causing another to be deceived by any false or misleading representation, by withholding information, by preventing another from acquiring information, or by any conduct, act, or omission that creates, confirms, or perpetuates a false impression in another, including a false impression as to law, value, state of mind, or other objective or subjective fact. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of the offense, such knowledge is established that the person subjectively believes there's a high probability of its existence and fails to make the inquiry or actual conscious purpose to avoid learning the fact. Proof of motive is not required. Presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. For an act is a crime, a good motive and purpose is not a defense. Restrain one of his or her liberty means to limit or restrain Dustin Hunter's freedom of movement. Restraint not be for any specific duration of time or in any specific manner. Substantial risk means a strong possibility as contrasted with a remote or significant possibility that a certain result may occur or that certain circumstances may exist. Serious physical harm to persons means any of the following: any mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment, any physical harm that carries a substantial risk of death, any physical harm involves some permanent incapacity, whether partial or total, or involves some temporary substantial incapacity, Any physical harm that involves some permanent disfigurement or involves some temporary serious disfigurement, or any physical harm that involves acute pain of such duration as a result of substantial suffering or that involves any degree of prolonged or intractable pain. Now, the law under which the defendant is charged in count 2 is entitled robbery, and is numbered Ohio Revised Code 2911.0282, and states in pertinent part as follows: no person in committing or a theft offense or fleeing immediately after the attempt or offense shall do any of the following: inflict, attempt to inflict, or threaten to inflict physical harm on another. The defendant is charged with robbery under this section. Before you can find the defendant guilty, you must find beyond reasonable doubt that on or about August 30, 2018, in the Highland County, Ohio, the defendant did attempting or committing a theft offense or in fleeing immediately after the attempt or offense shall do any of the following: inflict, attempt, or to inflict, or threaten to inflict physical harm on another. So the essential elements of the offense of kidnapping are as follows: that the defendant did 1, in attempting or committing a theft offense as defined under ORC 291302, or fleeing immediately after the attempt or offense, did inflict, attempt to inflict, or threaten to inflict physical harm and thus inflict. And the offense occurred in Highland County on or about the day alleged in the indictment. The instructions that I gave you regarding the time and the venue of the offense, the first count, are also repeated here and apply to this count as well. Now, before you can find the defendant was committing or attempting to commit the offense of theft under RC 29130281, you must find beyond reasonable doubt the defendant did with purpose to deprive the owner, thus the owner, of property. 2, 3, knowingly obtain or exert control of the said property. 4, without the consent of the owner, first or authorized to give consent. And 5, the offense occurred in Highland County on or about the date alleged in the indictment. Purpose: to deprive the owner of property is an essential element of the offense of grand theft. Theft. A person acts purposely when it is his or her specific intention to cause a certain result. It must be established in this case that at the time in question it was present in the mind of the defendant a specific intention to obtain or exert control over the property of thus the owner without his consent. Now, when the essence of the prohibition is the offense's prohibition against conduct of a certain nature, act purposely, regardless of what the person intended to accomplish thereby, if it was the person's specific intent to engage in conduct of a certain nature. Purpose is a decision of the mind to do an act with a conscious objective of producing a specific result or engaging in specific conduct. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to himself unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act is determined from the manner in which it is done, the means used, and all the other facts and circumstances in evidence. Proof of motive is not required, and the presence or absence of a motive is one of the circumstances bearing upon purpose. If an act is a crime of good motive or purpose is not an offense. Now, deprive means to do any of the following: withhold property of another permanently for a period that appropriates a substantial portion of its value or use, or purpose to restore it only upon payment of reward or other consideration. Dispose of property so as to make it unlikely the owner will recover it, or accept, use, or appropriate money, property, or services with the purpose not to give proper consideration in return for the money, property, or services without reasonable justification or excuse for not giving proper consideration. Owner means, unless the context requires a different meaning, any person other than the actor who is the owner of, or has possession or control of, or has any license or interest in the property or services, even though the ownership, possession, control, license, or interest is unlawful. Property means any property, real or personal, tangible or intangible, and any interest or license in that property. Now, a person acts knowingly, regardless of purpose, when the person is aware the person's conduct will probably cause a certain result of being of a certain nature. And the person has knowledge of circumstances when that person is aware such circumstances probably exist. The knowledge of the existence of a particular fact is now an offense. Such knowledge is established, and the person subjectively believes there is a high probability of its existence and fails to make inquiry or action with a conscious purpose to avoid learning the fact. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You'll determine from those facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability his conduct would probably cause a certain result to be of a certain nature. Purposely includes knowingly. And again, motive is, the definition I gave you motive earlier applies. Consent may be either expressed or implied. Express consent is determined by written or spoken words of the persons involved. Implied consent is determined by the facts and circumstances which surround those involved, including their words and acts, from which you may infer consent to given to the defendant. What means the cause? A criminal attempt is when one person does or fails to do anything which is an act or omission constituting a substantial step in a course of conduct planned to culminate in his commission of the crime. Constitute a substantial step, the conduct must be strongly corroborative of the actor's criminal purpose. Preparing, planning, or arranging the means for the commission of the crime does not constitute an attempt. It's not an offense to a charge of attempt, and in retrospect, the commission of the offense which was an object of the attempt was impossible under the circumstances. Threat means a statement or conduct, whether direct or indirect, exerting pressure or submission to overcome the will of another, or make another fearful or apprehensive of injury or harm. Physical harm to persons means any injury, illness, or physiological impairment, regardless of its gravity or duration. Now, the defendant may be convicted of either or both counts, either as a principal offender or as an accomplice, which is known as complicity. Where you can find the defendant guilty as an accomplice of either count in the indictment, you must find beyond a reasonable doubt that on or about August 30, 2018 in Hyde County, Ohio, the defendant knowingly aided or abetted another in committing either or both of the offenses set forth in counts 1 and 2 in accordance with the instructions given to you regarding each of those counts. Knowingly is the same definition I previously gave you, as well as how you determine that and the motive. Aided or abetted means supported, assisted, encouraged, cooperated with, advised, or incited. Now, the state will still prove beyond reasonable doubt that the essential elements of the offense set forth in counts 1 and 2 were proven by proof beyond reasonable doubt set forth in the instructions regarding those counts. It's no defense to a charge of complicity that no person whom the defendant aided or abetted has been convicted as a principal offender. However, the defendant cannot be convicted as an accomplice unless the principal offense of count 1 or 2 was actually committed. Now, the defendant claims the affirmative defense of duress, that he acted out of fear for his life or of great bodily harm. When a person is forced to participate in an offense against his or her will because he honestly believes and has good reason to believe he's in immediate danger of death or great bodily harm, and that there was no reasonable opportunity to escape, he is entitled to be acquitted on the grounds of duress. The burden of going forward with the evidence of duress and the burden of proving that affirmative defense are upon the defendant. Must establish that offense by preponderance of the evidence. Now, preponderance of the evidence is the greater weight of the evidence. That is, evidence that you believe because it outweighs and overbalances in your mind the evidence opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative value. It is the quality of the evidence that must be weighed. Quality may or may not be identical with a greater number of witnesses. In determining whether or not the affirmative defense has been proven by preponderance of the evidence, you should consider all of the evidence bearing upon that affirmative defense, regardless of the producer. If the weight of the evidence is equally balanced, or if you're unable to determine which side has the preponderance, then the defendant has not established the affirmative defense of duress. If the defendant fails to establish the affirmative defense of duress, the state still has proved to you beyond a reasonable doubt all the elements of the crime charge in counts 1 and 2 of the indictment. So if you find the defendant proved beyond reasonable, the state proved, let me start over. If you find that the state proved beyond a reasonable doubt all of the essential elements of the offense of kidnapping as set forth in count 1 or robbery as set forth in count 2 of the indictment, according to your findings, your verdict must be guilty as to that count. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of kidnapping as set forth in count 1 or robbery as set forth under count 2 of the indictment, according to your findings, your verdict must be not guilty as to that count. The charges set forth in each count constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count of the indictment separately. You must state your findings as to each count and influenced by your verdict as to the other count. The defendant may be found guilty or not guilty of either or both offenses charged. Now that completes the substantive instructions, and just to give you a little comfort, we will have a copy of these with you in the jury room once I made them. I always find a number of edits when I'm reading something, no matter how many times I've done this. This is getting like 100 plus cases that I've done as a judge. But I will make those edits, and then we'll have that with you in the jury room during the deliberation. All right, now, we're now at the stage of closing arguments, and so each of the attorneys will outline, what they believe the evidence has shown in the case. They are not evidence, but are simply each attorney's argument as to what that evidence was and what it was shown. The state has burden of proof, so because of that, the prosecutor can make an opening portion of the closing argument, and then a rebuttal closing after the defendant has presented his closing. So at this time, Ms. Paul, take a hand and state.
May it please the court to steer it off. Ladies and gentlemen of the jury, I first want to thank you for your time and attention to this very serious matter today. We are one of the few countries in the world that uses a jury system to decide guilt in a case, and that only works with citizens like yourselves who take your jury service seriously. And for that, I want to thank you on behalf of my office, the Sheriff's Office, and the victim, Dustin Hunter, in this case. Now, as the judge said, I have two opportunities to address you in closing because I have the burden of proof, so I will keep this first opportunity short and to the point. On August 30th, 2018, Dustin Hunter agreed to drive two men who he thought were his friends to Hillsborough. They promised to pay him $40 for gas money. At the time, he never suspected that the real motive behind this drive was to beat and rob him. As he drove into Highland County, an area he wasn't familiar with at all, he was instructed to stop the vehicle. It became clear at this first stop that Dustin was not with the friends that he thought he was with. It was at that first stop that Brandon McComas demanded his belongings, and when Dustin refused, McComas began choking him with his seatbelt and beating him in the head. When he was instructed to drive on, he did so and then stopped a second time. This time, he tried to escape the beatings in the backseat of the vehicle and was tackled along the side of the road and dragged back to the vehicle. At this point, Brandon Engel took over driving so that Brandon McComas could continue to beat Dustin and demand his belongings. As McComas beat Dustin in the head and face with his fist and with a speaker, Brandon Engel, this defendant, drove the vehicle, not to get help, but to a dead-end road where the two could escape. And that is just what they did. They loaded up everything they could carry, and they fled, leaving Dustin Hunter unconscious in the car. They had no idea if he would wake up and what sort of damage they'd done. Brandon McComas and Brandon Engel were complicit in kidnapping Dustin Hunter. They restrained his liberty in such a manner that was a substantial risk of serious physical harm to Dustin. They left him unconscious, lying in his own cube. When the two loaded up all they could carry from Dustin's car and fled, they committed a theft offense. Dustin told you he did not give them permission to take anything from the car. And they committed that theft offense by causing physical harm to Dustin. That is robbery. Ladies and gentlemen, Brandon Engel is equally complicit as his co-defendant, Brandon McComas, and is guilty of both robbery and kidnapping. Thank you.
All right, thank you. Ms. Deardorff, you have a minute.
Thank you, Judge. Good afternoon again. I wanted to start with one of the first things that the judge read to you, which was, reasonable doubt exists when you cannot say you are firmly convinced of the truth of the charge. And to me, what you've heard over the last several hours is exactly that. The state of Ohio has the burden to prove to you that my client knowingly assisted Brandon McComas in the robbery and kidnapping. They have to prove to you through evidence that that is exactly what happened. And I want to go through some of the evidence that you did hear to explain to you why they have failed to meet that burden. Starting with Mr. Hunter. A true victim, as I said at the beginning, No one is here to dispute that whatsoever. Nor are we here to dispute that Brandon McComas committed serious crimes against him. So why do I talk about him? The factors that I mentioned when I opened are important to determine whether that man wanted to rob and kidnap him. They've known each other since high school. They grew up together. There's been no issues before Brandon McComas. That's important when you're analyzing, as the instructions say. You can't get into the mind of another person. And that's why Brandon McComas' actions that day are so important for you guys to consider. My client testified he paid him for a ride the day before. When McComas accidentally took some property, Brandon was the one that gave it back. It's important when you're analyzing, you're going to be back there saying, what did Brandon do? What should he have done? Was what he did a crime? All of these little factors add up, and you say, does it make sense for him to then go kidnap and rob him after everything else you know? Paid him for a ride, took him to IHOP, paid for a meal, paid for the ride on their way to the party over here in Hillsborough. Even the stop, and I know some of these things are probably like, why is she hammering on this one point? But it goes towards his mental state, which is a really important thing that you guys are deciding. When Brandon McComas told Dustin to pull over, we'll walk from here, did Brandon Angle sit and turn to him like, all right, let's go? Did he wait in the car and say, yeah, give us your stuff, it's 2v1? He immediately got out of the car. That came from Dustin. That's not coming from us here, at trial, we're trying to tell you, yeah, he got out of the car. That came from Dustin himself. And those little details, like I said, are important when you're determining whether this guy had that intent. He got out of the passenger seat. McComas would not stop beating on just Dustin and Brandon telling him not to. And I think that's important when you focus. That's something that Dustin said. He doesn't stop when you say stop. So I know the prosecutor got up and asked him questions. You didn't call 911. You didn't run. He doesn't stop when he's told to stop. McComas went in a rage that day and beat up Dustin and took his stuff. Telling him to stop wasn't enough. And I asked the victim some questions about that because it was important that that was what was said in the first interview. And that Brandon corroborates that today. There was evidence that they were fighting back and forth and that stopped in the car. There was evidence that Brandon McComas talked about a gun. All of that is important to go towards him. And like I said, the victim is a victim. Everyone in this room would agree that. But what's important is what he didn't say, and I said that in my opening. Brandon didn't touch him. He didn't yell at him. He didn't stand there and just watch and say, go get it, keep going. If you just cooperate and give us your stuff, we'll stop. It's really interesting to me that of all of the statement, there was not one thing that he could say that my client said that indicated he wanted to participate in that. Not one. Wouldn't you think if somebody was complicit in a robbery and kidnapping, you would hear one statement from him asking for something, or at least encouraging Brandon McComas? Not to mention, it's absolutely clear he didn't touch him. Dustin couldn't testify that he took anything from him. He said they took some things, but he also said that he was unconscious at some points. And Brandon Angle unequivocally told you he did not take a single thing from him. The prosecutor they called Cheyenne. 4 years later, she's very, very clear of what she sees two people leaning over. But she's also inconsistent with some things that Dustin said. She can't describe them at all. She says she drives down for 5 seconds and said that they're leaning over punching, but Dustin never said that Brandon was punching him or leaning over in an aggressive manner. And I think that's sometimes the problem with 4 years of eyewitness testimony. She's here to testify about a kidnapping robbery. She's going to get up and say, that's what happened to that victim. But is that really, why wouldn't Dustin have said that? We didn't hear from the officer that he got an actual sworn statement from her at any point. That would be nice to know exactly the details that she saw that day, not 4 years later, here at Drive. You've already seen that there can be inconsistencies even from the victim in the case, who is just trying to do the best to tell what he recollects. Brandon did not threaten him, yell at him, demand anything, hit, punch, kick. He actually didn't even call Dustin that day to set up this arrangement. Dustin called him looking for his belongings, and he obliged. And she's going to get up and say, I presume, in rebuttal, you don't have to be the principal. He does not have to do all of these things and get up and punch him and threaten him and say, give me your stuff, and we'll get out of here. And I 100% agree with that. Going back to the example of Gaudier about the getaway driver, I absolutely agree that if someone peels up and drives and then commits a crime, they're complicit. But you have to prove that they're complicit. And that's the thing that they really can't do. He doesn't have to testify. We could argue everything through Dustin, but he got up and told you exactly what happened that day and why he wanted nothing to do with the assault that happened with his friend. Even where the car was left was unusual, I thought. In the middle of nowhere, stops, gets out. At that point, state has to prove to you that that drive actually assisted Brandon. So that's one thing that they have to prove. That that drive aided and abetted Brandon McComas in doing everything. Well, let's think about that. That car had to drive somewhere, okay? If Brandon had run, Dustin is left with McComas, who's acting completely insane. Would we be here for something else if something ended up happening to Dustin? I don't know. But we know that that drive ended this. Nothing happened when he was in the back seat of that vehicle. Nothing. As soon as he stops that car, they leave, Dustin calls 911. The phone detail. Why would he volunteer to tell you that he told him, oh, leave the phone, it could be tracked? He was very clear that was so Dustin could call 911, which is exactly what he did. And I talked to you guys in the beginning about whether or not you agree with someone's behavior. You're going to be analyzing back there, well, I might have called 911, I might have driven to a different location, I might have done blank. That's fair. Maybe you would have in the moment. But really what you're deciding is not, I would have called earlier, or I would have kept running in that cornfield and said, I don't want anything to do with this. You remember, both witnesses, Dustin and Brandon, the only two that were there, said he yelled out Brandon. He comes back. Which is interesting because they're asking you to find someone guilty because they disagreed with their actions that day. But that's not enough. You heard all of these instructions about crime and intent and the risk of physical harm and wanting to aid and abet. And even the definition of aid and abet. Aid and abet, they have to prove to you, means he supported, assisted, encouraged, cooperated with, advised, or incited. The only act that they can get up here and talk about is the drive. And they have to prove to you that there was the criminal intent, that the driving helped with the kidnapping and helped with the robbery. And they just cannot. It's odd to me that of all of this case, you have a victim get up and testify there was not one other fact, anything that he did to drive that car from the ditch to where the Dustin got off. That's it. That's odd to me. It's not as though the victim got up and said, yeah, he threatened me and he pushed, and then we're getting up and saying, no, that's not how it happened. He just remembers wrong. He didn't say that even with his own memory. So we're kind of in agreement about some of the facts here. It's just whether or not that's a crime. And that's what you guys are here to decide. And that's why you're here to listen and give him the opportunity to tell his side. Because that was not given before the charge. And that's, if the officer listened to the statement, took it, filed the report, no harm done, I guess. But he got up and told you that he didn't want any part of this. And all of the details support that. Why didn't he take any of this stuff? It just doesn't make sense. Since you cannot look into the mind of another, knowledge, which you have to find granted, is determined from all the facts and circumstances in this evidence. You will determine from those facts and circumstances whether there existed in his mind an awareness of the probability his conduct would cause a certain result or be of a certain nature. They have to demonstrate to you that he knowingly drove that car because I wanted to help Brandon promise this. It's just the driving. And even after the fact, what did Brandon do? He didn't sleep at all. Gets a ride back to his house and tells his mom and dad what happened. Doesn't seem very indicative of a criminal. Never sees Brandon again. He did not want this to happen to his friend. They have to demonstrate to you each and every element. And why I say this to you is because in the beginning when I talked about us, then who do you believe more? I hope that after everything that came out, after you were able to hear Brandon tell what happened that day, what he observed, how he was feeling, that you find you believe him. But you don't even have to. But you have to believe them. Because that's the way the system works. They have to prove to you beyond a reasonable doubt on every element that they are saying you did, beyond, so that you're firmly convinced that they're accurate before you can write guilty. And even if you find that, I urge you to read the duress section. Because the burden of going forward with the evidence of duress is an affirmative defense. And that's true. So even if everything I said, you believe them, you're going to say guilty. If you also believe that we demonstrated to you the affirmative defense of duress, which is that he acted out of fear for his life or great bodily harm, you have to say not guilty. So our position to you is that they cannot prove that he's guilty of this offense, but even if they do believe that he is, I urge you to look at the evidence we put on for Brandon and find him not guilty on that affirmative defense. And I presume the prosecutor will argue that there's no evidence, there was no gun to his head, there was not a knife, it wasn't an overt threat. But they're asking to find Brandon guilty because of the threat that Dustin experienced, which can be through inference, doesn't have to be overt. And he witnessed the acts that Brandon McComas was committing and said that that scared him. He said that he was frightened, that it was shocking, it was behavior enough, abhorrent enough that he would never speak to him again. So how on one end can you ask for the guilty finding because the actions of McComas satisfied all the elements, but not enough for him? It can only apply to Dustin and not to Brandon. And so when I urge you to consider everything, I ask you to look at his testimony, and that we're almost in agreement on a lot of the facts. But that our position, we hope that you come back after everything I've said, you read the instructions, that my client is not guilty of this offense, and that you sign not guilty on both of this. Thank you.
Okay, Ms. Collins, you have to say.
Ms. Deardorff would ask you to believe, basically, if I understood her argument correctly, that because Mr. Eagle was kind on August 29th and they were all friends, on August 29th, he couldn't have done this on August 30th. It just wasn't in his nature. But at the same time, she says that Mr. McComas was also with them on August 29th. Remember, they went to IHOP and they were all friends. But he did do this on August 30th. Her client couldn't have. And that just makes no sense to me. How you can't commit a crime on the 30th because you were nice on the 29th. Now, she would also ask you to believe that Eagle isn't complicit because they didn't talk. So they didn't discuss anything. Of course, we only have his word for that, him saying they didn't talk. But under her theory, basically, if you're unable to speak, we could never commit you of a crime. Or never convict a person of a crime, no matter what the crime is. You can't talk to the other person. You can't be complicit in what they're doing, so you can't be convicted. And that's just not the law. It's not even kind of the law.
a person can be convicted of a crime based on their actions, and that's what we have here. We have really strong actions, not just inaction, but actual overt, I'm gonna do it actions. And that's what he is guilty of. Now, she also talked about the phone a little bit. I'm just gonna touch on this because she said that he left the phone on purpose. He told him it was so that they could be tracked, but really it was so they could call 911. And in fact, that's what Dustin did. Only that wasn't the testimony. Actually, the testimony was that Dustin beat on the door of a house 2 doors down until finally someone came, and they called the cops. So I just want to make that clear. I'm sure during the trial, and this always happens, even as before cases go to trial, there are things that are mentioned and they aren't developed, and they leave questions in our mind, like, well, why didn't we talk about this, or why didn't we talk about that? But remember the judge's instructions. A lot of times there are legal reasons of why we are allowed and are not allowed to talk about some things during a trial. And as the judge has instructed you, the evidence and the testimony that can be considered is only what you learned in court. So it's the testimony from that witness chair up there and the evidence in the form of the exhibits that you'll be given. In considering the testimony and evidence, it's important to remember that nothing but the defense attorney said in her questions is evidence. Only the answer from the chair is evidence. So, for example, when Ms. Deardorff walked up to Dustin Hunter and had the affidavit and said, where you wrote in here that he got out of the car and walked away, talking about Mr. Engel. And then I approached and said, where does it say that? And it didn't say that. The fact that she told you that it said he got out of the car and walked away, that's not evidence. It's not testimony. And in fact, was proven not to be accurate. Now, one of your main jobs is to weigh the credibility of the witnesses. And to do this, you apply the same test for truthfulness that you apply in your everyday lives. You look at how a person appeared on the stand, their manner of testimony, their reasonableness of testimony, their opportunity to see, hear, and know the things they are testifying about. Look for their frankness, their intelligence, their interest, and their bias. And taken with all the facts and circumstances surrounding their testimony, you decide whom to believe. Some points that I made for the witnesses that you've heard from today. Dustin Hunter was the first witness to testify. We all agree that he was the victim of a horrible crime, and as the victim of the crime, he had the best opportunity to see and hear what he was testifying about. He truly has first-hand knowledge of the crime. He was there. He has nothing to gain by testifying here today. More importantly, he has no bias in the case. He answers the questions of both the prosecution and the defense as best as he can remember. Cheyenne Vollmer was the next witness that you heard from. She's a true witness that basically saw something, it alarmed her, and she called 911, what we hope everybody would do in that situation. She was driving with her young children on that evening. She drove by a small dark-colored car. She saw, according to her testimony, which is the evidence that can be considered, 2 males standing over a third male that was laying on the ground. She said that the male on the ground was screaming for help. It appeared the 2 other males were beating him or trying to drag him into the car. She thought he was in danger. And she called 911. She said it's the only time she's ever done something like this. Now, did she know the color of sweatshirt they were wearing? No. And as officers, we wish that witnesses could pick that kind of stuff out, but it happens fast. And honestly, thank God she called 911. At least somebody was alerted to start looking, and that's what they did. J.D. Adams, Sergeant Adams, started looking. And she said she slowed down to about 15 miles an hour during that stretch to really get a look at what was going on the side of the road. So did she see it for 3 seconds, 5 seconds, 10 seconds? I don't know. But she saw that. And Dustin confirms that, yeah, they were out, and he tried to run away from the car at that point and was brought back. So it makes sense, it does coincide with what Cheyenne saw. Again, Cheyenne has no interest, no bias. She doesn't know Dustin Hunter, doesn't know Brandon Eagle, doesn't even live around here now. She has nothing to gain by testifying today, nothing to lose. She is simply telling you what she saw. That's it. Sergeant J.D. Adams responded to the area that Cheyenne described, but he was unable to locate Dustin, Brandon, or the defendant. And finally, you heard from Deputy Steve Alexander. Deputy Alexander responded to the scene and collected evidence, taking pictures of the scene so that others could see the scene just as he saw it on August the 30th of 2018. Again, he simply laid out the investigation. He has no interest or bias in the case. His job, telling you what he saw, what he did. Make it so that you can see it through his eyes. You'll have the pictures when we walk out, you'll get the exhibit, so you'll be able to see what he saw. Again, no bias in this case. Nothing to gain, nothing to lose. He just presents the evidence. Now, finally, you heard from the defendant. And he's the only person that you heard from today that truly has a bias in this case. He truly has an interest. His bias and interest is that he hopes you don't believe the state. He hopes that you believe him. He's the only one with a reason to be dishonest. He wants you to believe that he was threatened by McComas, and that is why he complied. But Dustin Hunter, again, he is in the best position to, he's the victim. First-hand knowledge, he was right there. He didn't hear McComas threaten the defendant not one time. He didn't see McComas put hands on the defendant not one time. So he's just afraid because of what he sees, afraid to the point of driving and hoping. It's going to take more than that. If it's true that McComas threatened Eagle, why wouldn't Dustin just say so? Why would he say so at the beginning? He doesn't have anything to gain by Eagle being brought into this. He is simply relaying what he saw, what he heard, and he did not hear that. Now, the reason you only heard about those threats from Brandon Eagle is because Brandon Eagle is the only person with a reason to make up those threats. Ladies and gentlemen, perjury is not that big of a deal to someone that would drag his friend into a car. Not that big a deal to someone who will drive a car while his friend is puking in the back seat and being beaten to unconsciousness. And then steal from the friend and tell the accomplice that you're with, hey, leave your phone, leave the phone, you don't want to be tracked. That definitely is a reason to make up that story today. Now, as you deliberate in the case, I agree it's important to go through every element of each crime and remember the evidence that was presented to prove each element. Let's start with kidnapping. The essential elements of kidnapping, this is in your jury instructions: by force, threat, or deception, knowingly under circumstances creating a substantial risk of serious physical harm to Dustin Hunter. No question there. Restrain the liberty of Dustin Hunter, and the offense occurred in Highland County on or about August 30th, 2018. Now, number 4, backwards to forwards. Highland County, Ohio, on or about August 30th, 2018. I think there's really no question that this occurred in Highland County. The area, the different locations that were described by Dustin, who, while he's not familiar with the area, understands the road between 138 to 50, and then Cheyenne, Solomon, Fairview, that's where J.D. Adams responded to, and then they end up on Spiegel Street, which is down 138 towards Creekville. So there's no question that all of that occurred in Highland County. No question it occurred on August 30th, 2018. Number 3, restrain the liberty of Dustin Hunter. First of all, they refused to let him go. He testified that he tried at least twice to run away from the vehicle, was tackled and brought back to the vehicle. That's restraining his liberty right there. That's all it takes. It doesn't take a rope. It doesn't take a gun to the head. it's dragged back to the vehicle. Look at the size difference. And we had testimony that Mr. McComas is just a few inches taller than the defendant, and the defendant is heavier. Compared to Dustin, those two boys are, have quite a size difference on Dustin. He's much smaller than the two of them. And you saw him here in court today, so we can decide that. They refused to let him go, tackled Dustin and he tried to run away, put Dustin in the back seat, and then drove Dustin where they wanted to go. He had no idea where he was when he woke up. He walked to the neighbor's house, 2 doors down, started beating on a door until someone came out and helped him. He didn't know where he was. That is restraint with liberty of Dustin Hunter. Knowingly, under circumstances, created a substantial risk of serious physical harm to Dustin. They beat him with a speaker about the head. They beat him to the point that he was puking, to the point that he was unconscious, and left him unconscious in the back seat. Now, ladies and gentlemen, I want you to pay specific attention to these pictures when you get them. There is a picture that Deputy Adams took so that you could see the scene from that night that really shows the knocks on the side of Dustin Hunter's head. It is substantial, the beating that he underwent. Beating someone with your hands, beating someone in the head with a speaker, tackling someone, dragging them down the road, leaving them unconscious, not knowing if they are alive or dead, all a substantial risk of serious physical harm to Dustin. They had no idea when they left him if he would wake up. Look at the knots on his head. Remember his testimony that he passed out and came to you multiple times, that he puked in the car, that he was bit in the chest. Taken together, this is all a substantial risk of serious physical harm. And we've met the second element. By force, threat, or deception is the last element of kidnapping. There are a few cases where you have more force than in this case. The beating, the threats, the physically dragging him back to the car, putting him in, holding him in the back seat, and then stopping at a place that's completely unknown to him. He had no idea where it was. Ladies and gentlemen, the state has proven each element of kidnapping beyond a reasonable doubt, and the defendant is guilty of kidnapping. Next is robbery. Again, I go through the elements easiest to hardest. No question, Highland County on or about August 30th, 2018. We've already been through it. The area that he traveled in Highland County ended up on Steeple Street. Did inflict, attempt to inflict, or threaten to inflict physical harm on Dustin Hunter. I'm not going to delve into this again. You guys look at the pictures in this case from the hospital. This boy was beaten mercilessly. In attempting or committing a theft offense, as defined in 29-1302, or in fleeing immediately after the offense. The theft offense occurred on Steeple Street. They get out of the car, they gather up stuff in the car that Nicholas was asking for the whole time. Speakers, Oakley sunglasses, some other small things in the car. I asked Dustin Hunter when he was testifying, did you give them permission to take anything from your car? And the answer was, no, I did not. So when they took stuff, that's theft. He identified things that were missing. They took them, that is theft. And they were in the car earlier because that's what McComas was demanding from the very beginning when he's wrapping the seatbelt around his neck. They stopped the car, gone, that's theft. He didn't give them permission to take that stuff. And because of that, because they were committing a theft, and they caused injury, and it happened in Highland County, he's guilty of robbery. We've proven again each and every element beyond a reasonable doubt. Now, Engel can be convicted of either charges or both charges as a principal offender or as an accomplice, which is known as complicity. Aided or abetting. Supported, assisted, encouraged, cooperated with, advised, or incited. He drove the vehicle with the beaten, sick, unconscious Dustin Hunter in the back seat while Dustin was begging to be let go. He supported, assisted, and cooperated with. When they're on the side of the road, what does Cheyenne say? It looked like they were dragging him back to the car. They were both standing over him. I felt he was in harm. She thought he was, in harm's way, just driving by. Of course, Dustin was screaming for help as they were driving him. Drove the vehicle with the beaten, sick, unconscious Dustin Hunter in the back seat. Supported, assisted, and cooperated with Brandon McComas. Took Dustin's Oakleys and front speakers. I guess that he wouldn't be complicit in the robbery of the phone because he told him to leave the phone, but why did he tell him to leave the phone? So that they couldn't be tracked. That's still aiding and abetting. That's still encouraging. It's still acting as a cover for, it's still encouraging, cooperating with, advising, and supporting. They don't have to sit down and have this isn't like the movie Ocean's 11 where they sit down and plan the huge robbery at the casino. His actions, him simply saying, hey, leave your phone, or leave that phone, we don't want you to track us, that's enough. Him driving Dustin, that's enough. They don't have to be talking about it. They don't. That's just, I'm not sure. You'll not see that anywhere in the law, that they have to talk about it. That's not in your jury instructions because that's not the law. His actions alone are enough. Now, the state has proven each and every element beyond a reasonable doubt. The defense would ask you to find that Brandon did this, and the defendant was basically an innocent bystander that he did nothing wrong. Look at the complicity. He aided and abetted. He supported, he assisted, he encouraged, he cooperated. Engel actually drove with the victim in the back seat, unconscious, puking, and being beaten by McComas. And she says nothing happened after that, but the testimony from Dustin was they get to the Treewood Apartments, and he tells them again, don't you dare think about running. No one here is going to help you. But it's still going on. They're still restraining him. And who's driving the vehicle? This defendant. He's the driver. Finally, when they have abandoned Dustin in the backseat of the car, both Brandon McComas and Engel gather up what they can carry, they take off. Again, Engel even tells them, leave the cell phone, we don't want to be tracked with that cell phone. Now, the state doesn't have to prove a motive, but ladies and gentlemen, the motive here is really clear. They wanted a ride to Hillsborough, they wanted a ride to a party, and they wanted Dustin's belongings. And guess what? They got all the things they wanted. Now, the defendant wants you to believe that he was operating under duress. I want you to read the instructions under duress. Engel must believe that he is in immediate danger of death or great bodily harm, and he had no reasonable opportunity to escape. First, there is no evidence that he was in danger of immediate danger of death or great bodily harm. He was not threatened. At one point, more than one point, he gets out of the car. He could have run away. He could have walked away. Well, she says, well, would that have been better? What would we have been here for? Would it have been worse? Dustin turned out no better for his staying. Engel had plenty of chances to escape. He's the driver of the vehicle, so and Cook's in the back seat. He's really in control of the situation. He could have, we know they drove past Taco Bell. Dustin even remembers that. Pull in there. Do something. No, he didn't do anything because he wasn't afraid. He was acting with. He was doing exactly what McComas wanted him to do. Engel admitted that he stayed with McComas at his grandmother's on Anderson Road, and while Engel wants you to believe that McComas is 6 inches taller and much larger, we know that that isn't even true. Deputy Alexander is familiar with McComas, very familiar with him. Only a couple inches taller than the defendant, and the defendant is actually heavier. So even his explanation of why he was afraid, it being because McComas is so much bigger than him, we know it's not true. He made that up. And if he made that up, what else did he do? Ladies and gentlemen, if this dress existed, if the fear was there, why not talk about this 4 years ago? The reason is because today it's convenient to be afraid. The state has proven, remember the example of the getaway driver in the bank robbery scenario we talked about in jury voir dire. When bank robber 1 goes into the bank and shoots the teller, bank robber 2, who is sitting in the car, is guilty of that murder because he aids and abets. He drives bank robber 1 away. Did they talk about him shooting the teller beforehand? No, because that is not a requirement of the law. It doesn't matter if they talked about it. The bottom line is, as soon as he drove away, knowing what's happened, he's complicit, not just in the bank robbery, but also in the murder. He doesn't have to hold the gun. He doesn't even have to touch the money. That's not what the law says. Does he aid and abet? Does he support? But when you're driving somewhere from the scene, or in this case, driving the scene around, you're clearly supporting. The state has proven each crime beyond a reasonable doubt. And Ms. Deardorff does what so many defense attorneys do, blame the cops. Well, this is Little Highland County, so they don't know what they're doing, so it had been better if Sergeant Alex or Deputy Alexander would have done this, and he would have done that, and he would have done this. Don't fall into the CSI, NCIS. That's what they do on TV, so why didn't we do it? It's when all else fails, blame the cops. They should have done better. Well, you're going to see the evidence. You're going to see the pictures. You're going to see the scene. He took pictures of the scene, and he's given them to you today, so you'll get to be able to put yourself right back there. The next thing is they always talk about reasonable doubt and it being this huge mountain that can't be overcome. It's really just not. It's not. It is a high burden of proof, and I want you to hold me to that high burden of proof, but don't make more of it than it is. As I've always heard, don't make a mountain out of a molehill. Reasonable doubt is doubt based on reason and common sense, and you can equate it to your own everyday lives. For example, let's say you're going to buy a car. You shop around, you collect the evidence. You really want a red SUV, and you find one and the odometer says $50,000, and the payments will be $250 a month. Your budget allows for $350 a month. This is everything that you want in an SUV. All the evidence points to you buying this car. And, of course, you decide to buy the car. Now, is there some remote possible doubt that this is not the right car for you? Of course there is. But reasonable doubt based on reason and common sense, has been overcome, and you buy the car. It's not your job to look for reasonable doubt. If reasonable doubt had existed in this case, it would have presented itself from the evidence. In this case, reasonable doubt based on reason and common sense, has been overcome, and the state has proven each element of each crime beyond a reasonable doubt. Ladies and gentlemen of the jury, the state has proven each of the elements of each crime, and as such, I'm asking that you return a verdict of guilty as to all counts. Thank you.
All right, ladies and gentlemen, you've heard the arguments of counsel, and as I indicated to you previously, they are not evidence. Now I'm going to instruct you on how to conduct your deliberations. Prepare your verdict once you reach it. You must be uninfluenced by any consideration of any sympathy or prejudice. It is your duty to carefully weigh all of the evidence and decide all of the disputed questions of fact, to apply the instructions of the court to your findings, and render your verdict accordingly. In fulfilling your duties, your efforts must be to arrive at a just verdict. To Consider all the evidence, use your common sense, and make your findings with intelligence and impartiality, without any bias, sympathy, or prejudice, so that the state defendant will feel that their case was fairly and impartially tried. Now, if during the course of the trial, the court has said or done anything which you consider as an indication of my view of the facts of the case in general, your instructions are disregarded, because as a judge, I must be, and I sincerely do desire to be impartial, presiding over this or any other case, whether it's a trial by jury or not. Because the court doesn't have any right to interfere and invade in any way in your decision by indicating a preference, and the court has not done that in this case. The reason I give you that instruction, and this is not an instruction, I'll just tell you from personal experiences. I was a trial lawyer for 32 years before I became judge, and tried a lot of jury cases, somewhere around 200. And I had a client in one day and had been on the jury, and so I said to this client, I said, you know, I've never been on a jury, probably never will. Just tell me what goes on in the jury room. How did you come to your decision? And this client looked at me and said, well, we just kind of went back there and talked about what the judge had done during the case, and we figured out that he thought that this was the way it should be, so that's the way we went. And I didn't say anything, but I was absolutely flabbergasted, because that's clearly not the way it's supposed to be. So what I say to you is that if you think that anything, any comments I made or my rulings are any way a hint as to what your verdict should be, it is not. I'm just trying to be like an umpire, calling them as I see them. Now, your initial conduct upon commencing deliberations is a matter of great importance. It's not wise to immediately express a determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position even if you later decide that you may be or you are wrong. Now, consult with one another, considering each other's views, and deliberate with the objective of reaching an agreement. If you can do so without disturbing your individual judgment. You must each decide the case for yourself. You should do so only after a discussion and consideration of the case with your fellow jurors. Now, do not hesitate to change an opinion if you find that it's wrong. However, you should not surrender an honest conviction in order to be congenial or to render a verdict solely because of the opinions of other jurors. Now, when you go to the jury room, your first function will be to select one of your number as a foreperson. That person you select will preside over your deliberations, but does not have any greater power, nor does that person's vote have any greater importance than anyone else's. Foreperson serves the purpose of helping you to conduct your deliberations in an orderly manner and give each juror an opportunity to express your opinion. One additional duty of the foreperson will be to see that the verdict forms, exhibits, and copies of instructions are returned to the court once you reach the verdict. Now, until your verdict is announced in open court, you're not to disclose to anyone else the status of your deliberations or the nature of your verdict. Now, this being a criminal case, before it can be said that you've reached a verdict, it is necessary for all 12, I'll repeat, all 12, to agree upon a verdict, as in each count. Now, in addition to the exhibits which you will have with you, the court and the substantive instructions once I've edited them, you'll have 2 verdict forms. And I know you can't see them there, but it'll look like this, and there are some signature lines. And the first verdict form has a name of the case, the case number. It says verdict count 1, kidnapping, and it says the section number of the statute. Then it says, we, the jury, have been duly paneled and sworn, find the defendant, Brandon Jonathan Engel. Then there'll be a blank space in the middle, and then underneath that, there's a couple of asterisks to call to your attention to where that is where you insert either guilty or not guilty in ink. Of kidnapping, a first degree felony, she stands charged with count 1 of the indictment. And then there's 12 signature lines. Count 2 then is basically the same, except it has robbery, a different section number, and then it reads the same way, and you'll insert the verdict or not, of guilty or not guilty of robbery, a second degree felony, as he stands charged with count 2 of the indictment. Now, after you've done that, each of the 12 of you will sign your name on each form in ink. And that's because all 12 of you must agree on the verdict in each count and sign it, or you don't have a verdict. Your signature on the verdict forms indicates you concur in the verdict, and that is your verdict. Now, during the deliberations, you'll be in charge as bailiffs. They'll ensure your deliberations are not interrupted. They'll be your means of communication with the court. They cannot answer any questions about the case, so if you have a question or a request, write it down and knock on the door. It'll be the door right here. It goes back to chambers because you will be deliberating in here rather than in the jury room. Again, we're trying to take precautions for safety. And so knock on the door and give that to the bailiff, and then he'll give it to me, and after I review it with the attorneys, I'll determine the response and return it to you in writing the response. Now, I can't promise you that I can give you what you want. I can only promise you that it will be considered and I'll respond. So, for instance, if you, as was brought up earlier this morning on the board here, one of the witnesses, well, if you ask for something, we would like to have whatever. If it's not an exhibit, I can't give it to you because it's not evidence. So even though there may have been testimony about that item, it wasn't evidence, wasn't admitted, so you can't have it. And I believe you'll find that there is no Exhibit 2, that's because it was not offered, so don't be surprised when you have Exhibit 1 and then 3 through 17. We will leave those in the court reporting. And then I'll also give you the instructions in the verdict forms after I've made the corrections. Now, once you've reached the verdict, knock on the door and inform the bailiff, then you'll take your seats back in your chairs because you are going to be deliberating here as indicated. And then I'll come in with the attorneys and the parties, and we'll then go back on the record, and your verdicts will be announced in the court. Now, again, before you start to deliberate, you'll need to have all of the attorney yourself on the bailiff if you didn't already, and then you'll keep that outside of the courtroom because you're not permitted to have any means of communication. And I'm going to shut off the computer will go to sleep, but you're not permitted to get on computers or anything else and look up anything at all. It will be limited to your discussion of the exhibits and the testimony and the written instructions and verdict. All right, is there anything for the council?
No, Judge.
All right, ladies and gentlemen, I want to thank all of you for your patience, your cooperation, and your attentiveness. You've been very attentive through this trial. It's been a short one, but a thorough one, I think. And I believe that we've not wasted your time presenting the case. You've done a good job in doing that very expeditiously. We took time to make sure that you had the right to present the case fully. Now, Ms. Setti, you are the alternate, and so you will not be remaining. You'll be leaving after everyone else clears out, and also attorneys will need to clear out all of the paperwork and everything. Don't leave anything in here. But I do want you to give your phone number to the bailiff. Go ahead.
All right, here.
All right. So because, and not to be more than 20 or 25 minutes away, if you need to go to work, you work a second shift, just have to let them know that if something happens, we might need to call. And I've had it in, I forget how long I've been, almost 14 years as a judge. Twice I've had to have I've had a juror that was in deliberations that had to be excused, and so we had to call the alternate in. And so until you get word from the bailiff that the case has been completed and the verdict has been returned, you're to continue to abide by all the instructions I gave you, including not discussing the matter with anyone, not forming any opinions about the case, or expressing them to anyone. Don't read or listen to anything about it. Don't look at anything in the newspaper, online, or listen to any reports on radio or TV if there are any. I don't think there will be, but in case there are, don't post anything on social media about it or anything about your experience until you've been told that you will not be required to come back for review because the case has been complete. And once that happens, you're free to discuss it if you wish with anyone, but until then, you're not to discuss anything. So you may go ahead and be excused at this time. And also, I say other spectators leave, and the court then will go ahead and make these changes. And you can move about the room and use the tables if you need to, look at anything, whatever. There is, again, the bathroom back there, the jury room, if you need to use it along with water and coffee. And you may need to make some fresh coffee, I don't know how old it is, probably made this morning. If you want to make coffee, I think you have everything back there that you would need. And if there's anything else you need, like a soft drink or anything, let us know, and we'll go down and get it. But I think we all
We going to do that bond review or not? Okay.
All right, and so you go ahead.
All right, sir.
All right, then, ladies and gentlemen, then we'll begin your deliberation.